Actually, we were in an executive session, and we just came out of executive session, so the meeting's already in order. First item on the agenda, as always, is the Pledge of Allegiance. Please rise.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, first item, announcements. Any announcements from the board or staff?
Yeah, if I could, I've noticed over the last several weeks that there's an anonymous group of citizens that have been skulking about beautifying Hartford Avenue on their own. They went after the little traffic island where Linwood Street goes into the avenue and cleaned up all the trash. They pulled the weeds and planted flowers and put in the border. And then they attacked the little traffic island up at Upton Road, where Upton Road joins Hartford Avenue. They did a very good job of it. So we don't know who they are because they haven't come before us to ask Nanny, may I? But they've certainly taken the initiative. We have to applaud them for that.
I have an idea who it was, because I saw them doing it, but I'm not going to...
Okay. Well, the downside of that, I don't know if they're aware that there was an ordinance passed in 1695 that anyone that improves common land without the approval of the selectmen will be fined 4 pence.
And what's that equate to
Okay,
these days?
yeah, what is a pence?
It's part of a shilling. I think there are 14 pence in a shilling,
And how, okay, and what's a shilling?
20 shillings in a pound.
All right. Any other announcements?
I may have that wrong. It's been a while since I dealt with old pennies.
Bruce, Cari, any announcements?
I'm on.
No. Okay, we've got a very, very full agenda for this evening, a number of public hearings. Our executive session also ran a little bit longer than we planned. So we do have citizens forum scheduled. I am going to respectfully ask everyone to hold their comments to no more than 2 minutes per person, just because we have such a full agenda here, and the board's taken on a policy that we are going to try to wrap up our business by 10 o'clock this evening. So if I can see by show of hands, anyone who feels need to address the board can do so. I'll give you 2 minutes to do that. So, all right, Mr. Chauvin, so you're going to go up first.
Good evening, ladies and gentlemen, Mr. Chairman. My name is Daniel Chauvin. I live at 181 Providence Road in the town of Linwood. I just have basically a question for the board, or a couple of questions. In regards to the complaints filed against Chief Freitas. When the complaints were filed, requests were put in for information, which state law says you have 10 days to do. That 10 days has gone well over what it should. My question to the board is, because the complaints were filed against Chief Freitas, is the fact that he is the custodian of those records and the one holding that record, is that or is that not a conflict of interest?
Don't know that I can answer that question from a legal perspective. As keeper of the records, though, he would be responsible for providing the records.
But if your complaint is against the keeper of records, does that now make his position holding those a conflict of interest? In my opinion, that's indisputable.
Okay.
Mr. Chairman, if I may, the chief could delegate responsibility to review, assemble, and provide records to another employee if he felt that there was any potential conflict of interest involved.
Okay.
In fact, I believe the chief has delegated the public records responsibility, several of the public records responsibilities in his office to another officer within the department.
You're right. Okay. And you had a second question?
Well, my second question is, if it is a conflict of interest, why is this being allowed to happen?
I do believe that the statutory responsibility lies with chief, but as indicated by Mr. Costello, that he's delegated the actual administration of that.
I'm getting information that he is physically withholding information from us. And that he is the one holding those records. Chief Freitas is the one, and that it has not been delegated to anyone. If that is true or false, I'm not in his office, I don't know, but that's the information I'm getting. And, you know, my question is why? What's the delay?
Mr. Chairman, if
Yep.
I could address that. I mean, you have filed a complaint, and we're in the process of hearing that complaint. And at this time, since we're in that process, I feel that the board should not comment any further on that matter.
Yeah, I would agree.
You've already filed a complaint, and that's where we'll leave it at that. Thank you.
Sorry, I saw another hand up in the back row. I'm sorry.
My name is Wendy White. I was here on September 8th, and I was told at the end of the meeting that the board was going to write some letters to the animal control and the chief to find out what the story was with everything, and I never got any response, so I was wondering if anybody did write any letters or got any response. Well, that was one issue. I know I don't have much time. The second issue was that I did come in with a formal complaint on October 7th, and as I approached the mailboxes, my paperwork was grabbed out of my hands by Ms. Myers. She said she had to timestamp it. 2 days later, I did call Mr. Baghdasarian and ask if he had a copy of what I was going to put in his mailbox, and he said that he did not. So my question is, why was my paperwork seized from my hands, and why was it not put into the mailboxes?
Okay. Let me address the first thing. Your September 8th complaint is under discussion by the board, okay? So,
Okay.
again, as Ms. Robertson said, I'm not going to make any more comments on that this evening. Relative to how paperwork is handled when it comes into this office, you know, essentially, administrative support to this board who are not here on a day-to-day basis, you know, we have, you know, just tacitly authorized, you know, the town manager or her assistant to handle paperwork as it comes on our behalf. We are not here on a daily basis.
Oh, I understand that. It's
okay.
just, they were sealed envelopes. I don't see the point of somebody taking them from me, and I just don't understand the reason. I guess I was wondering why.
The procedure is for them to be stamped, and so, you know, because there is action that comes in and out of the building, that wouldn't be uncommon for them to hold them aside for us.
So it takes a few days to stamp
It-
something.
From the time that it comes in.
Well, that's all that's.
No, it doesn't
that's
take a
all-
little time to stamp it. No, it's stamped on the day it comes in.
Okay.
But the fact that something might have arrived and was not physically in one of our hands when you had a conversation with us is not indicative of any, I mean, there are things, you know, I may not be in here for several days at a time, that kind of thing. So.
Well, the only gentleman that did get his copy that day is this gentleman here, because he was sitting here. But as I understand, he got a gag order or something put on him, so he's not able to speak.
These are out of line, these comments.
Yeah, you've used your 2 minutes this evening, thanks.
Okay, thanks.
I saw one other hand in the back. No, I'm sorry, ma'am. I don't know your name.
My name is Shirley Chauvin. I live at 181 Providence Road, Linwood. I appreciate the opportunity to speak. My husband, Daniel Chauvin, addressed the board at your last meeting. Until today, I've been silent, but I feel compelled to speak at this time. First and foremost, on September 17th, a public information request was signed for by Town Hall personnel. Here is the receipt. As you know, public requests are supposed to be honored within 10 days of receipt. Copy of Massachusetts General Law. It has been 40 days, and we have not yet received one shred of paper. I'm holding a copy of the law in my hand. How is it that the board and the chief of police are allowed to disregard state law? I implore this board, as the supervising entity of the chief of police, to cease this deliberate and illegal actions undertaken by you and your employees and honor the request that is required by law. Nowhere within the statute does it make reference to a chief of police or other municipal entity having the discretionary powers in regards to the release of public records. That means the complete record, no missing pages, no misplaced files, no mysteriously deleted information, just a full and honest compliance to the law. I would like to direct my final question to the chairman, Mr. Kuros. Is it my understanding that you intend to run for state representative?
That's true.
If elected, will you not then, for all intensive purposes, be a lawmaker?
Sure.
After witnessing your handling of this blatantly illegal withholding of public information by someone under your direct supervision, and your deliberate disregard for the rights of citizens, the thought of you in a position as lawmaker is indeed disturbing. Thank you.
Mr. Kujalski thanks you. Representative Kujalski sends his regards for your comments. Thank you.
I don't want to get into an argument, but when a public person requests documents under the Freedom of Information Act, we're required to acknowledge that request within 10 days. But the compilation of the documents may well take longer than 10 days. So there is no malfeasance in not providing a stack of documents within 10 days. The interpretation of the law by the Secretary of State's office makes that so. So that's sort of, not to be argumentative, but there is an interpretation of the law.
There's a lot of gray there,
Right.
but I see what's going
Right.
on.
And the recourse, quite frankly, is to file a complaint with the state secretary's office.
40 days and 40 nights, do I
If-
have to make a biblical
I'm not going to get into an argument with you here, but you certainly do have recourse, and that would be to file a complaint with the state secretary's office if indeed you so choose to do that.
I believe in the law, it does state
Yeah.
that it would be up to the supervisor, the director, the keeper of records
Okay.
to report if something isn't being done.
Okay.
And I don't think that that's happened.
Mr. Baril, you raise your hand? Yeah.
Michael Baril, 143 West Street, Uxbridge. All right. As far as my public requests, talking on to that, it turns out mine was 35 days over the 10 days. And I do wish to applaud publicly Sergeant Emerick from the Uxbridge Police Department, who basically, once upon getting my request from possession of Chief Freitas 12 days after he had hidden the envelope, that he processed my request promptly, immediately, and very professionally. And I will give you just an example of what I have. This is the packet which took Chief Freitas 4 weeks to process. As you can see, there's only a few pages. This is the packet I received from Sergeant Emerick in less than 5 days, multiple times faster than what Chief Freitas has done. So this shows you what one person does who's truthful and ethical and does their job. And this shows what someone seems to has to spend 4 weeks to figure out which emails not to put in this packet.
Mr. Baril, those comments are out of line. I really do think
How
they're
can
out of
they be
line.
out of line?
They're out of line. You're making accusations here that.
I'm not making action. This is a
are
public
across the
forum.
line.
Am I not allowed to
Right.
say my
Right.
free speech to speak?
Sure, and you just used your 2 minutes. I'm going to ask you to move on.
So you're basically saying I'm done.
You have
Yes,
40
I-
seconds, sir.
Is it 40 seconds? Okay.
40
Take
seconds.
another 40 seconds if you like.
Okay. All right, anyhow, going on. Regarding the missing papers for the fire department, thank you. The missing papers for the fire department, I filed a public records request to this office, which was addressed to all Board of Selectmen. None of you never saw it. It was processed. The packet's right there, 600, it's supposed to be 638 pages. It turns out, I come here, view the documents in Kim's office. I say I can't get that possession. We have to photocopy it. 2 days later, I come back to pick up the packet, and there's 21 documents that are missing, which it turns out those documents that are missing include emails and correspondence to the state police.
All right, I'm going to cut you off there, but my understanding is that we still have an original copy here in the office. You're welcome to come in at any point, do a page-by-page comparison. And you know, I would even extend the offer that the 21 pages that are missing, I'd be willing to pick up the tab on those 21 pages if you know, that's a big
Well, that was my
concern of
other thing
yours.
too. Yeah, I paid for 6:30 and I didn't get to.
And that's
Thank you,
fine.
thank you.
And so you're welcome to come in here with your packet, compare it to the master packet, note any missing documents, and we'll get those to you.
Okay, and then the last quick thing was
That's it.
just.
I'm sorry.
Oh, okay.
Okay, thanks.
That's it? All right.
Yep.
Thank you for your time.
Mark? Oh, I thought you, Howard, did you raise your hand? No? Okay.
And I'm sorry, this law states that they have 10 days
No.
to comply. It doesn't say to consider. Just to correct.
Thank you again.
All right, we've got a number of public hearings tonight. First of which, gravel permit renewal for 175 South Street, permit number 71, Eli Richardson. Okay. All right, can open the public hearing. Monday, October 27th, 7:15 PM, Board of Selectmen's meeting room. Board of Selectmen will hold a public hearing to consider an application for the renewal of gravel permit number 71 for 175 South Street, map 55, parcel 2255, submitted by Elias Richardson III, Richardson-North Corporation, 314 Chestnut Street, Uxbridge, Mass. 01569. Can I get an update from staff as to?
So this is a renewal of the permit, and from what I understand, and I'll leave it to the applicant, that it hasn't substantially changed since last year. Is that the case? Not much? Okay. So typically we talk about existing conditions and what's changed in the renewal. So if you wanted to give the board an update of
After that, I really don't want to say nothing.
you would please.
Now, there's only been like 6,000 yards removed, and it's very small. It still is only a 5-acre open spot, if any, and we're haying places where.
Excuse me.
Yes, please.
Why was a public hearing required if it's a renewal?
Right. It had been the board's practice.
If I thought we changed that.
Right. Well, I did want to discuss that this evening, though. I believe we had one or two conditions with this license in the past that there was a concern with. But I think we do want to get in the habit of, if there are no concerns moving forward, foregoing the public hearing process. We're just trying to be consistent so that we treated all gravel pit applicants the same and trying to be consistent across the board. But I mean, I'll defer to the board's, opinion on whether we want to hold hearings for, for even, kind of run-of-the-mill renewals, or if we only want to hold hearings if staff raises any concerns relative to any conditions being met. Because
I don't think we should have a hearing unless there is a concern.
I mean, the application document that the owner has to go through for a renewal is so exhaustive that unless staff notes something in it, I don't think we need further public hearings on a renewal.
I
Let me
visited
point
the
something
property.
out in the application process. I'm looking at what my
Form,
says,
yes.
page 2 of 4, and the 1, 2, 3, 4, fifth line from the top, where you're asked to indicate the zone that the operation is in. It says business, and there's a block. It says, stop. Commercial gravel removal is not an allowed use in business zone. There's no such thing. And I mention that to point out once again that the people who have been in charge of these issues do not understand the laws under which they operate. There's nothing in our bylaws that say you can't remove gravel in a business zone.
So you're, okay, so
He's
I guess from a
criticizing the
side,
form, not
no,
the application.
correct, that's right. So the
Right.
form needs to be possibly updated, especially if section
if section numbers have
section
changed.
numbers are not in conformance with the current bylaws.
Okay.
So then on that matter, we would request an action item, Mr. Chairman?
Yeah.
And what's the action item?
That the form be reviewed for
By
updates.
By
by
the
the town
same
manager?
people who wrote the thing in
Can't
the
be.
first place?
That's Rachel Langton's form.
This is a sidebar conversation we can nail
Correct,
down.
right.
Don't want to keep this gentleman waiting.
Right.
But is there anybody from the public that would like to weigh in on the operation of this gravel pit? All right, seeing none, I'm going to close the public commentary. Okay,
Motion to grant the renewal.
Second?
give it to Bruce.
Fighting over it.
All in favor?
Aye.
Aye.
Aye. Peter?
Aye.
Peter made the motion, Bruce seconded it. Okay, it's unanimous.
Thank you very much.
All right, good luck. All right, next we have a public hearing to vote the intent to lay out and make public the roadway and infrastructure known as and associated with Big Rock Road. In accordance with Mass General Law, Chapter 82, the public hearing will be held on October 27, 7:15 at the Selectmen's Meeting Room, 21 South Main Street, Uxbridge. All plans and related materials may be reviewed in the Board of Selectmen's office and it's in this location. All right. Update from staff?
Megan, our Director of Planning and Economic Development, has provided an update on the overview of the street acceptance articles, including a planning board report. For this particular one, she had noted that the layout is in process and that the planning board has recommended layout and acceptance with a report filed separately with the selectmen's hearing pending tonight. There's, from what I see, there's no issues with this matter, and I drafted a motion for the chairman to move forward for town meeting with a favorable recommendation to lay out.
Okay. I move, I was still an open public hearing?
Oh, you have to, yes, you're still on, so
Yep.
that information's there. I don't know, Megan, if you had anything else to offer in regards to the planning board's vote. Okay. There's had been inspections done by the former DPW superintendent, and everything looks like it's in order.
Okay. Is there anybody from the public that wishes to comment on this? Okay, I'll close the public commentary.
Okay. I move that we lay out and recommend acceptance of Big Rock Road and drainage easement A shown on a plan entitled Road Acceptance Plan of Big Rock Road dated May 2002, prepared by Andrews Survey and Engineering Company.
I'll second.
Okay, any discussion necessary? No? Okay, all in favor?
Aye.
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 Okay, just administrative note for the board. We have a number of things that need to be signed coming out of this meeting. Minutes, plans, all that. Kim had asked if we could make a point of just stopping in sometime tomorrow rather than shuffling paper around during the meeting, just to make sure that everything gets signed. Okay. Okay. Are we,
Each of them are posted separately.
I'm sorry?
Each of the public hearings are
Okay.
posted separately.
Are we going to open the hearings if indeed there's no motion on some of these?
I think you need to receive the information, is that correct?
Receive information,
Okay.
you would, yes.
Okay.
Can we mention the public hearing and mention all the roads?
Yes.
It'll save time.
It's actually just, it's Casey, Gary Lane, and Commerce. Same state, same,
They're all the same.
Yeah.
okay,
that was it.
okay. All right, I'd like to open a public hearing, October 6th, October 27th, the Board of Selectmen, I'm sorry, on October 6th, the Board of Selectmen voted its intent to lay out and make public the roadways and infrastructure known as and associated with Casey Court, Gary Lane, and Commerce Drive Extension. In accordance with Mass General Law, Chapter 82, the public hearing will be held on October 27th, 2008 at 7:15 PM in the Selectmen's Meeting Room, 21 South Main Street, Uxbridge, Mass. All plans and related materials may be reviewed in the Board of Selectmen's office. Okay. All right, any update from staff on these
Sure.
three?
Just lost my place. Casey Court is submitted under, and Gary Lane are submitted under Article 37 of the Fall Town Meeting warrant. The layout process has been initiated, and the planning board is still reviewing the status of it. At this time, they have not deemed it complete to date. So I think we have two issues before us. One is to keep the public hearing open and continue this item, or take no action with no motion. We're up against a timeline. The layout plans would have to be on file with the town clerk's office 7 days prior to town meeting for action to occur on it. Right now, it doesn't look like the applicant is going to be able to make that timeline. Planning board can still offer a report. It's a non-binding report, but a report for town meeting. And that's the policy decision if the board wants to take any action or continue this.
Is it anticipated that all the requirements will have been met by the time of town meeting, or by the time that the planning board has to make a recommendation?
I have to defer to Megan because she's had direct contact with the developer on this.
Good evening, thank you. I have no way of knowing for sure. That's certainly the objective. In the case of Gary and Casey, the subdivision has been ongoing for a number of years, was very recently before the planning board getting an extension of time within which to complete the project. They very recently received a waiver of certain construction requirements. But on last inspection by the consulting engineer, there was still a laundry list of items to be attended to, plan revisions that I have not seen yet that are required. So I don't know for sure. But that's why the planning board has kept open their deliberations so that the layout process could actually continue moving through, although clearly not with the ability to meet acceptance at this coming fall annual town meeting.
So if we're not gonna be able to accept at this coming town meeting, then there's no reason to take any motion this evening then, right?
There isn't. If you voted to lay it out at some point, I think it could remain on file for the May town meeting, but we'd go through this process all over again with any other roads that come through. So staff would recommend that we not continue it based on Megan's comments and just take no action.
Okay. Okay. All right, do I have anybody from the public that wants to weigh in on this? No? Okay. All right, I will close public commentary. Any motion from the board? Or?
Just for the record, it's listed as Casey Court / Gary Lane, just so everyone knows that there are two names on this street.
There's two different roads within the development.
Yeah, it's the same subdevelopment with two different roads.
Yeah.
So is this particular motion or discussion related to Casey Court or Gary Lane?
Both,
Both.
correct?
That's Stonecrest, right?
Right. I'm sorry?
Is that Stonecrest?
They're both.
Yes.
Yeah.
Right.
Yeah, the Stonecrest subdivision is two phases. So
Right.
from Aldrich Street, you've got Gary Lane, and then the circle is Casey Court. That's Stonecrest 2, but it's part of the same overall project.
So just no motion, I mean, it's necessary at this point.
So we don't have to do a motion to no motion, okay?
Take a motion to not make a motion?
Yeah.
Did you close the public hearing?
I did. Okay. And we also covered Commerce Drive.
Commerce Drive is Article 33, and it's the exact same situation. So staff's
And
recommending no motion.
I had included that when I opened the hearing for Casey and Gary. Okay. So I think we're okay. All right. Next item is a public hearing to consider an application for a transfer of a liquor license for Quitting Time, 300 North Main Street. Let's see. To open a public hearing, Uxbridge Board of Selectmen will hold a public hearing to consider an application for a transfer of liquor license for Riyadh Gira. I apologize if I've mispronounced her name. Applicant, Gira Marketing, Inc., doing business as Quitting Time Package Store, 300 North Main Street, Uxbridge, Mass. 01569. First, I would just ask staff to weigh in on this, if we could.
The application is complete. The board recalls there was a attempted transfer with a different buyer a few months ago that was approved by this board,
Right.
by the ABCC. However, the
Mr. Gary, do you want to share any comments with the board?
Good evening.
Have any questions? Anybody have any questions for Mr. Gary? No? Hey, I just, my fundamental question just is, your plans for operating the business consistent with current operation?
Same exact, yes.
Okay, same hours of operation?
Same hours, yeah. We're gonna, I don't know if I need to say that, but we're gonna be adding the lottery and the scratch ticket to it.
Okay.
It's been removed, but I just wanna say that right now.
Yeah.
Everything's gonna be the same.
And do you have experience in running this type of business in the past?
A little bit,
Yeah.
a little bit. I have some family members working with me, and they kinda know about it more than me.
Oh, okay. Anyone from the public care to weigh in on this? Do you have any other comments you'd like to share with us? No? You're on TV.
Just,
now's
we
your chance
just,
to advertise.
we just want you to welcome us here, that's all.
Yeah. Okay. All right, I'm going to close the public hearing then. All right.
Motion to grant the transfer of license for Quitting Time, 300 North Main Street.
Second?
Any discussion? No? All in favor?
Aye.
Aye. Very good, it's unanimous. Good luck.
Thank you, thanks a lot.
Thanks.
And just a note, thank you to staff for the spreadsheet.
Yeah, that's very helpful, actually.
Yes, thank you.
Our eighth and final public hearing of the evening. Open a public hearing to consider an application for a retail alcoholic beverage license for Beverly Kessler, applicant, the Haywagon Inc., 504B West Hartford Ave, Uxbridge, Mass. 01569. Ms. Kessler?
Excuse me.
I am Bill Kessler, it's my wife Beverly. We have made this application for a beer and wine license just to expand the beverage options for our patrons in the dining room area. It's not we will not allow any alcohol to be brought outside nor serve any alcohol through the food windows. It'll be specific to the dining room area. We have no intent to set up a bar. It's purely for our dining customers. And we're not looking either to expand the hours beyond what was given on our common victuals license. I don't recall if that was 10 o'clock or 11 o'clock, but since we've been open in April, our closing time's been 9, and we don't anticipate it changing.
I have a question. On the description of the premise, you refer to it as a seasonal ice cream business?
There is a seasonal, well, actually, it's not really, the hours are seasonal. We do serve ice cream year-round, but not outside. I mean, you're not going to come up in December for ice cream at a window, but we do serve it year-round inside.
I was going to say, people will.
Okay, so just so I'm clear, because when I read that, so your business, it's set up as a restaurant, not as an ice cream dairy parlor, correct? Just for clarification.
It's kind of set up as both. We do have a dining area inside. We have a kitchen that serves both the dining area, and we have a takeout food window. We also have a separate ice cream area that does serve ice cream outside through an ice cream window, April through September, but you can still have ice cream inside.
My question is,
Allow them to serve flaming ice cream desserts.
right, but you don't serve just ice cream. You serve hamburgers, hot dogs. Are you a full restaurant?
We are full, we recently expanded the menu, like Wednesday nights we have Italian food, Thursday nights are pub-style sandwiches, Saturdays surf and turf. So we have expanded our menu. The off-season, or our off-season from the typical summer season, we're just closed Mondays and Tuesdays. So in the winter time, we'll be open Wednesday through Sunday. Starting somewhere around the April time frame, it'll be seven days a week.
Okay, thank you.
Okay. Any further questions from the board? Anybody from the public want to weigh in on this? No? Okay. Close public hearing. Do I have a motion?
Motion to accept the.
Actually, before you
sorry.
do that, yeah, I'm sorry. Actually, can we have staff weigh in? All the,
Yeah, the paperwork is in order. I spoke to the building inspector. He went and conducted an inspection last week, I believe.
Yeah.
Last Wednesday.
The issue, we had talked about, given, this is the time of year when the ABCC is renewing licenses. During November, they renew for the following year. The question that the Kesslers have, and I followed up on, right now, the ABCC is saying it's 4 to 6 weeks, depending on the caseload of their investigators, to approve new licenses. The Kesslers have requested that the license be issued in December as soon as it's available, if the board is willing to consider prorating the license fee. Again, we have no guarantee from the ABCC when they will approve it. So if it happens to be January 1st, obviously we would look at charging the full fee for the next calendar year. But let's say the ABCC were to approve it in early December, the Kessler's question was whether or not the board would be willing to prorate the fee.
I thought we agreed, voted some time ago, that we'll go back to the system of prorating fees that by state law expire on a certain date.
I don't believe there was a vote.
I don't think we officially voted that either.
no, but,
Did we?
There's a consensus on the board.
yeah.
Okay. Well, that's.
So we
convert it
could.
to a vote. It's clearly unfair. I don't want to cheat people. I'm cheap, but I don't want to cheat people.
No, right, right, and I agree with you, Peter. Maybe we need to take the vote for that and then entertain the thought of the prorating specifically for this, or grandfather this after we do, you understand what I'm saying?
The implication is, if the license is being approved for this year or next year, and obviously there are no guarantees, given where we're falling in the year,
Right.
based on the ABCC's turnaround.
It would be prorated if it's this year.
Well,
By month or by day? I mean, if it's issued some point during December?
you would do it by days, I would imagine.
By day, it's just as easy.
Right. Right. Yeah. I mean, we don't have a formal policy on it. The policy that's on the books right now, I think, says that we charge,
The full fee for the
Right,
full year.
right.
So I guess that's my question. I mean,
Well,
I understand their concern, but don't we have to address our policy first
Well, I
before
mean,
we
and here's what we
issue
should do.
that?
We can put that policy discussion on a meeting for the 10th,
Yes.
okay? And vote.
We can close the public hearing, and we can take the vote on the 10th too, at the same time.
That delays the paperwork being forwarded to the ABCC, and the concern is, the Kesslers indicated if they have to pay the full fee, they might not want to seek the license for this calendar year, which we would need to note that on paperwork going in. So essentially, I think we're looking for an answer to both questions tonight.
Well,
But we
sticking to what
can't,
we have
the
is
second one
charter
we can't, because it's not on
requirement
the
that
agenda,
A
right?
specific item be on the agenda.
Right.
So we can't rule
If I
on
may make a suggestion,
Sure.
Mr.
Yes,
Chairman?
please.
The board could vote as a condition of approval of this license that you would prorate the fee based upon the effective date of the license as finally approved, whether for the remainder of this year or for the ensuing year. And then, as Peter noted, at your next meeting, when you have proper notice, you could adopt an overall policy to that end, applying to all license applications.
So moved.
Second.
You got that?
The motion was to approve the license. Help her out with that, Pat. Wait to have that read back to us. Okay. Peter made it, but can you read it back to us, so Peter knows what he said?
Motion to approve the license on the condition that the fee be prorated based upon the final effective date of approval.
Do I have a second?
Second.
Bruce, second. Any other discussion necessary? Like, only comment I want to make is actually that addresses things moving forward as well, that license is wherever your license is granted, whatever time of the year. So if their license comes in January 30th, they're going to pay for 11 months only, rather than the full, 12 months, assuming that that's the direction we go, based on our, policy of prorating. We'll talk about it next meeting.
Well, and you bring up a good point. I mean, you can also set it that anything within the first 6 months receives the first rate, and then after the second month, we could set it up that anything
Yeah.
7 through 12 is then prorated based on the year. I mean, they're just things for the board to consider when we actually do the motion.
Yeah.
Call for the vote?
Aye.
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 Good luck. All right, consent items, we have a number of,
Don't we have another?
Don't we have another
no,
application?
that was it.
You have
Very
the
patient.
Our
Oh,
Lady.
you're right, you're right. Sorry. Okay. All right, open public hearing to consider an application for a one-day alcohol license for Mary Pat Wickstrom, applicant on behalf of Our Lady of the Valley Regional School Holiday Fair to be held at 75 Mendon Street, Uxbridge, Mass. 01569, November 22nd, 2008, from 9 a.m. to 3 p.m. Okay. All right, if I recall, this is an annual event. This is probably the fourth or fifth time they've done this, I believe.
Mary Pat couldn't be here tonight. If you have any questions, she's available on the 10th, but she explained the event will be similarly held as it has been in the past. Tents will be set up at the back of the parking lot, similar as they've done in years past.
Any questions from the board? Discussion? No? Okay.
Motion to grant.
Actually, anyone from the public want to weigh in on this? No? Okay. Close public hearing. Good. Motion to grant for Peter.
Second.
Second by Mike. Any discussion necessary? No? All in favor?
Aye.
Aye.
Peter?
Aye,
Oh,
sorry.
it's unanimous. Okay. All right, we've got, 1, 2, 3,
Put off the minutes until the end, so the people who are here for something don't have to wait.
We just have to remember them this time.
Yeah.
right? Right. Okay, town manager report?
Thank you, Mr. Chairman. I'll keep this very brief because you have the written report in your packet. DPW superintendent recruitment. I explained the process in my report. 2 candidates really stood out from the many that applied, and I've interviewed both of them, and I've made an offer to one of them. And so now I'm waiting to hear back from the person. There's quite a few DPW superintendent director positions that are open, and we're open around the same time, and they're all making their offers around the same time from other towns. So I'm hoping to hear something favorable within the next day or two. If one candidate declines and I go to the second candidate, who I think is just as good, it was basically a flip of a coin. If that person doesn't accept the appointment, then I would recommend that the recruitment effort be placed on hold and let the successor town manager handle the recruitment in light of there's pending town meeting action as well. I don't think that there were any other candidates going deeper into the list that would serve the town as well as these 2 did. And so that would be my recommendation, but I'll certainly report that as we get closer to coming to terms. Both candidates had understood that the town-provided vehicle for community use is not available. And that's one of the benefits that other towns are offering, but many towns are also not offering. So it's a change in thought for many towns when it comes to community purposes.
Jill, did either candidate, did they apply for multiple, did they give you any sense, the one candidate that you chose? Do you think that there's a good probability, or do you have any sense on that?
Yeah, I think there's definitely one candidate. The other one I expect, it's a complicated process, but one candidate has, and it's not that complicated, but he has declined. And so the second candidate we're waiting to hear from. There's been, within the last 2 weeks, offers made, multiple offers to both candidates made. So they're trying to weigh their options. Both candidates, unfortunately, would have to buy a vehicle to take the Uxbridge position. And so that's something that they're weighing in on the total picture.
Thank you.
Why would they have to buy a vehicle?
because their family only has one vehicle.
They were provided cars in the past that they were using.
Yeah.
Gee, a one-vehicle family?
Department head meetings where we've started the budget discussions. We had one department head meeting scheduled tomorrow that we decided to postpone to the following week, just to get all the revenue projections and the worksheets out to the departments. The big budget book is used again, and the departments will also work on their budget narratives like they did last year. We don't have free cash certified yet, so that will come up in a following conversation with the board looking at the fall town meeting warrant. Not that we would use free cash to balance the FY10 budget, but there's a lot of stuff still pending that we're not sure, including what the governor may do with state aid, so that's another factor for us. So we're continuing with that, working to implement new technology. Our server had been down today. We have a new Exchange server that will allow a lot of coordination among the departments, including shared calendars and meeting requests, and it's something that's just somehow caused a little bit of a glitch in the migration, and as you probably know, it was pretty quiet around here with not many emails from staff to you today, but by tomorrow that should be all settled. And everything's been backed up. We haven't lost any data, so we're fine with that. Crown and Eagle meeting, the Director of Planning and Economic Development as well as Town Council had attended a meeting with Crown and Eagle on October 14th. Also present were the engineers from the Strathmoreshire Condo Association and their attorney. And if you want me to turn it over to Pat just to give a really brief update, I have a written update in here as well.
Thank you, Ms. Town Manager. There were several members of groups associated with all parties present, which is what we were hoping to do, is to get everyone out there. And it was a good meeting, very constructive meeting. It lasted about an hour and a half. We went through all the historical background documents relative to the layout and acceptance of the way. We did look very carefully at the issues relating to the subsidence of the wall and the roadway adjacent to it. Strathmoreshire did have its engineering consultants present. They offered their opinion as to the basis or cause of the problem. The Crown and Eagle folks were going to take a closer look at the issues. I believe they were going to have counsel engaged. They did have an attorney who was unable to make it on that day, but they wanted to have them present as well. From the town's perspective, the key issue here is whether or not we ever actually acquired a legal interest in that property. It does appear that portions of Crown and Eagle Road were accepted by the town at some point in time, but there's no record of any easement or fee deed ever having been conveyed to the town which would give us a legal interest in the property. And there's furthermore discussion as to what the cause of the problem out there was. The engineers for Strathmoreshire, which own the wall and the canals, were of the view that the raising of the level of the roadway so that it could have an adequate roadbed exerted pressure on the wall, pushing downwards, and thus forced it out, as opposed to what Crown and Eagle initially believed to be the case, was that the wall was collapsing on its own right, thus causing the road to subside. So as we expected from day one, it's really going to be an issue that will have to be looked at very carefully by engineering professionals to determine the cause, nature of the problem, and the method of fixing it. And with the three parties of interest working together, the town will presumably ultimately accept, if we haven't already, that portion of Crown and Eagle Road as a public way. Between the three parties working together, we hope to keep these dialogues going and come up with a resolution of it as soon as possible.
So that section of the roadway is not necessarily a public one?
I don't believe, Mike, that it was ever accepted by the town in compliance with law. The town meeting did in fact vote to accept a portion of Crown and Eagle Road. There were two subdivisions down there, the Crown and Eagle Apartments, then there's one further down to the south. And there seems to be some confusion of record as to what portion of Crown and Eagle Road was actually accepted, but there's no evidence of any deed ever having been recorded at the Registry of Deeds which conveyed the interest in the road to the town, which would then give us the proprietary interest in the obligation to repair and maintain. So we're going to follow up on that.
I guess I'm wondering, the obvious remedy would be to haul in a few loads of gravel and backfill the canal. Is the Crown and Eagle folks still talking about using that canal to generate electricity at some point?
There was not much discussion to that effect. I had heard the same possibility. I think all parties, both Strathmore-Shire, Crown and Eagle, and the town, are not only looking at the present situation, but what they would like to do in the future down there as hopefully an impetus to get the situation resolved. So that would certainly be a relevant consideration, because if the canal were no longer going to be used for any purpose, the simplest resolution would be to backfill it and go from there. But then we'd have conservation issues, et cetera, as well. That might make it a little bit more complicated. But that's really going to be their call, and no one's presented anything to the town, to my knowledge, to that end.
Is there any, I know that we're proceeding with this, but is there any position, because that road has the weight limits, because the main thoroughfare has been affected by this, which then is causing, is there any step that we can do that kind of moves this along? Because it has a financial impact directly to the town by having to reroute buses and truck traffic, and, which then is putting additional stress on our other roads, which ultimately causes the town, down the road, more money, as, the reason I bring this up is because we now have, we have a bridge issue now with 122. So if the trucks can't go down 122 and they can't go down West Hartford Ave, Route 16 is taking the brunt of the traffic coming into the town. And, we just fixed the bridge that we had at Lynch's. I mean, are we putting undue stress on the remaining avenues into this town by having these bridges out?
Oh, I don't think the Crown and Eagle Road situation has any bearing on that, just given the amount of traffic there. But in fact, the day we were out there for the site visit, there were Mass Highway Department staff out there doing some work on the bridge. I'm not sure what they're doing. But I mean, if that canal were to be closed and the need for drainage under West Hartford Ave would to be eliminated, that might resolve some of those problems. So.
As I recall, the portion of the canal that runs under Hartford Avenue was covered with wood beams at some point, and then the roadway put on it, and that's what is rotting away.
So that's an unrelated issue.
When they dug it out, they put metal plates in place of some of the wood beams down there, but you still have canal structure under the roadway that needs to be, something needs to be done.
Well, I guess more basic question. Obviously, we want the three parties working together to resolve this for the mutual, benefit of everybody. But technically, the town's not on the hook for anything right now, because based on your investigation, we have no ownership. We've not accepted those roads, right? And we have no legal responsibility at this point.
That's our view, and we made that position known to all the parties present at the meeting. I referred them to all the documents of record, all the deed references, whatever. They were going to be looking into that. Megan had done some subsequent research about what acceptances of roadways, layouts by this board and town meeting had been completed, and we have provided that information to Strathmore Shire and Crown and Eagle, and now they're going to have their staff look at it and follow up. We did set a timetable. I want to say it was like 45 days to reconvene, have another meeting, get everyone back together. So. But the town has followed up, and we have done due diligence. Mike got the ball rolling with some registry work. We followed up with that, did confirm, that in our view, who owns the wall and the canal. That's Strathmore Shire. And as of right now, I believe that Crown and Eagle may own the fee interest in the roadway, but they're going to look into that and get back to us, so that hasn't been finally established yet.
Okay, thanks.
Okay, I'll try to get through this a little quicker. Speaking of Crown and Eagle, I know that our legislative delegation has a capital earmark for $250,000 for repair to the canal, thinking that that might have been part of the reason for the road, what you just said, turning towards the canal. But that's part of the capital, not part of the governor's operating budget, so that might still be in there. The impacts to the governor's budget reductions, right now we know for sure that there's been a 23% reduction in our community policing funds. We typically get $18,024, and it's being reduced to $13,878, which is good news in light of the situation. We were concerned that it was going to be removed in its entirety. They're also continuing to fund the Quinn bill, which is a shared proportion for the education compensation, which is good. That's not 100% on the town, and that was a concern of ours as well. However, the $50,000 earmark for the ambulance ALS services has been removed from the governor's budget. There's some funding elsewhere, and the delegation had said that they would try to get public safety as a priority funding, so they're still working to get that $50,000. We had a town meeting warrant article, and we approved funding for that, and that's for the defibrillators and the computer equipment. So we do have a funding source, but we would sure like to use an earmark instead and redirect our funding. And then the capital bond items for the Blanchard/municipal buildings ADA study of $500,000 is still in, and the bond for the downtown revitalization, $3.7 million is still in. Most of the capital bonding items remained, as only the operational budgets were cut.
Before you go off,
Sure.
on a different subject? This is a different subject?
No, I was just going to talk about the GIC, but go ahead.
Oh, okay,
Yeah.
no, back on the grants
Mhm.
thing. The $500,000 for Blanchard, we're not gonna spend $500,000 fixing Blanchard, so we need to get the legislative people to allow us latitude in the use of those funds. We could use that money for the school feasibility study or other things that we need to do in town. It just doesn't make sense to renovate a building that we're not going to use because the ultimate sale of the building may make those renovations of no value. It doesn't make sense.
The capital request was put in about 2 years ago. Last year, Rep. Callahan had asked that the title be expanded, so it's Blanchard/Municipal Buildings ADA. So if indeed that's the route that we want to go, we have to notify the legislative delegation to expand. Or I'm not really sure if she wants to, Jen Callahan's been my contact, if she wants to actually remove it or have something with Blanchard so it's consistent with what the governor has seen before, as well as the other representation. So we'll see how that
Well,
can
I'd be
play out.
happy with that if Callahan and Moore and others went out and got jobs and earned that money, then they can decide how it's gonna be spent. But they didn't earn any of that money. The people of Uxbridge earned that money and paid it to the state. So if it's gonna be sent back here for our use, which is nice, we should decide the best way to spend it. It doesn't make sense to waste money on something that's gonna provide no benefit to the people of Uxbridge.
This is a borrowing, so that it's not done yet. So
No, I
the
know
entire
that. I know
state
that.
would feel it's
But I don't wanna
okay.
have a situation where, okay, here it is, here's the money, you have to use it for Blanchard.
And there's information in the reading file on the status of the Blanchard. We got notification from, I just forgot Jenna's last name.
Jenna Cruz, the Attorney General's office informed us that they had reviewed all the material that had been submitted, and they've determined that there are two parcels of land involved. The parcel without the school on it, the language of the bequest to the town is such that they feel we can sell it or devote it to another use. However, the language in the instruments that conveyed the parcel with the school on it, they feel would require us filing a cypre action with the court to obtain judicial relief to authorize us to sell it. The good news is that the Attorney General's office, which typically files the answer or defense to any cypre claim, has indicated to us, based on the materials they've seen to date, they would likely not have any objection to us doing that.
So have
we're
we
gonna-
filed that?
We're in the process
Okay.
of preparing that.
So nothing would prohibit us from moving ahead with plans to sell, looking for offers to purchase the building. We don't need to wait until all these steps are done. The more time we give to market, the better off we're going to be.
How long is the anticipation before we'd have a final ruling?
If it's completely uncontested, it would still likely take, 2 to 4 months, I believe, to get everything filed, have the court process the judgment and what have you, but I'll keep you updated on that. We're in the process of preparing that complaint. It's a fairly standard document. We'll have it filed imminently, and we'll hopefully have a judgment from the court shortly. It might be worthwhile, though, Peter, just waiting till we get the judgment from the court before we actually issue an RFP or market it, just so there wouldn't be any questions as to the legality of any proposed use.
What would be the question? inquiry would be subject to, board approval.
Okay, that's the question.
I mean,
Just
banks are
whether-
marketing foreclosed properties that they haven't even got a foreclosure decree on
Right.
yet. And they're not telling people they don't have a decree.
I guess my question would be, is for us to put an RFP out there, does the town incur any cost in order to do that?
Relatively minimal, but
It's
Advertising.
advertising,
I just don't know if the
Sample.
Attorney General's office would appreciate putting the property out for sale, though, before the process has been completed.
Just tell him you said it was okay, because you talked to him,
Yeah.
so.
Martha Coakley might not buy that. But we'll expedite it. I know it's an important matter.
you might have noticed that the portions of the accounting department are now in the former photocopier room because we had a mold issue in our basement that had come up through the door right in front of their former office. So we had air quality tests done today. I don't know the results of them, but the basement's been cleaned up. The immediate odor's been removed, and hopefully we'll get the release for Justin and Nick to go back in that office. And I've also asked for Nora to stay up here in our office just to provide us another person for backup to answer the phones. I'm not doing any work that the previous union employees had done, but having another person up here just would provide additional customer service for someone coming in.
I noticed in your report, a water pipe had been, quote, compromised, and I didn't quite understand how a water pipe is compromised. What happened? Did it break? Did it leak?
From what the basement remediation folks have said, it had leaked, causing some soot and potential mold, but I'm not sure it completely busted. Did you get that, Kim?
No, he said it looked, he couldn't pinpoint, it looked like over a long period of time there had been a leak or various leaks, very slow leaks. May not have been leaks, may have been condensation due to the moisture humidity in the basement. So it's been replaced and repaired.
Did anyone, other than the outside vendor, actually look at the pipe?
Yeah, this is all covered under our town insurance
No, I
policy.
know that.
Yes.
The people- Okay.
There was water dripping from the top.
That's an indication of a leak.
Of a compromise.
The disposal of the pickup truck on eBay, we received $4,858. It's been paid and the truck is gone, so that's considered a success story. Someone from Maine had picked it up.
I was prepared to offer $300 tops.
You skipped over the Moore breakfast, and I just wanted to comment that I came away from that with a new respect for Mayor Lukes of Worcester. She is, if anything, more cranky than I am when dealing with the legislators. I like that lady.
Roberta Schaefer from the Worcester Municipal Research Bureau also, Worcester Regional Research Bureau also chimed in, same platform. And I'm sorry to skip around. The part of the relief package for municipalities is the ability to join the Group Insurance Commission. The deadline had been moved from October 1st to December 1st. I asked David to prepare a fiscal impact scenario about some likely migration scenarios, sorry, and that's in your packet as well. BJ's truck registration, there's a memo in from David Utakis, the assessor who looked at it. His opinion is that the out-of-state vehicles would not be required to be registered here, as the owners of the vehicles are from out-of-state and have not rented or purchased real estate onto which to park the vehicles. I know David's here, Genero's here, and then he pointed out some motor vehicle excise trailer information from the websites as well.
I have a question on BJ's, is it the property itself that has the tax abatement, or is it the business that we gave? You know, the whole deal for the $10 million and businesses being run, is it the property that gets the break, or is it the business that gets the break?
It's the property as the project is described to the town when they apply for the Is this a TIF project?
It's a TIF, yeah.
It's a TIF. So it's the proposed project and use of the property that entitles the parcel to the abatement. Real estate tax, as you know, is assessed against a parcel of land. And
Correct.
the TIF rates that apply to that parcel of land as utilized under the TIF agreement.
Okay, so this is my thought process. If the parcel of land is not being used for the original presentation of the TIF agreement, then can we come back and assess additional tax on the businesses that are utilizing that property outside of the original TIF?
There's a process that has to be followed. I believe you have to seek decertification of the project from the Commonwealth, the Department of Revenue, or the EOEA would have to conduct a hearing to determine whether or not the original development plan has been complied with. If not, the project can be decertified involuntarily, or it can be voluntarily decertified if a property owner decides to sell the property and move on. But unless one of those steps is taken, we don't have a right to unilaterally just modify the assessment.
Okay, could it be viewed in the best interest of the town to look at decertification of that based on other businesses operating on that location outside of the original TIF? Therefore, the town is, we granted the TIF to BJ's to use that property, BJ's, but now there's campers being used by another company, and then kind of taking of the angle of, and we also have this trucking company, Cohen, using this as a storage facility, and attack it that way instead of just trying to go after the excise tax, or both.
I haven't heard of any of these issues. This is the first I've heard of it, but I'd be happy to talk to David about it. I mean, we could look at the agreement to make sure that there's compliance with the agreement. There are usually specific clauses in the agreement that address defaults or failure to comply with the use terms. So we could take a look at that and see what recourse might be available to us.
The camper storage and maintenance is a separate piece of property, and it's a business run by a separate entity.
They own that property.
Right.
That's not part of the BJ's
No, that's
property?
not part of
Okay, I
BJ's.
apologize. I thought that was part of the BJ's property. Okay, so if it's just the Cowan trucks using the location possibly as a storage facility, I don't know whether it's even worth, the value that would be received. I don't, you know what I'm saying? Is there really a net effect here?
They
But,
pick up $5,000 in excise taxes and spend $25,000 chasing it. I mean, right, may or may not make sense.
right, but if it's a situation where over, the length of the TIF, if it's possibly $5,000 a year over a 10-year period, it may be beneficial for the town to pursue something.
I know we
along
already
that
have a
lines.
pending appellate tax board appeal with BJ's on the TIF language that we're defending right now.
Okay.
So that was not brought up as part of the issues that I'm aware of. I'll speak with David about it, though.
But the trucks are part of the operation.
And that's gonna be their argument.
Yeah.
Is that this is not truck storage here. They're here waiting to
Yeah.
haul food out to our stores. I mean, is what their argument's
Those
gonna be.
trucks and trailers are expensive. People don't park them and leave them for no purpose.
They're only making money when they're on the road.
Yeah.
Yeah.
No, I understand what you're saying, but they're a separate business from BJ's. They're not BJ's trucks waiting to ship.
It doesn't make any difference. They're shipping products either into BJ's or out from BJ's.
Well, I guess my question is BJ's receiving any compensation from Cowan for those trucks
Yeah, they're
being
paying
stored at those
Cowan to
locations?
ship their product, and oh, by the way, Cowan keeps the tractors there until they need to pick a load of food up. So
Right,
I would
but
imagine
is-
BJ's is paying Cowan, not being compensated by Cowan.
Well, and to me that
Main
could,
undertaking for this TIF, even though I'm not in favor of these TIFs and
Right.
SMIFs, the company receiving the benefit agrees to employ a certain number of people and, increase employment and so on and so forth, and to add to the value of the taxable property of the town by constructing new facilities which weren't there before. Before BJ's, it was a sand pit, and now it's a building paying not its full share of taxes, but more than what the town was receiving before. And that's the basis upon which we give the TIFs.
I'd
agree.
like to open my own trucking company and just put Maryland plates on them and just sit them in my backyard, say, hey, I work for VJs, leave me alone. You know, I don't have to pay excise
If you read the
taxes.
material that's in the packet from the state regarding excise taxes, it's very curious. Because one section said you have to, you know, pay the Massachusetts taxes or have the liability insurance required by Massachusetts. So what do you have? Really nothing.
If I was a businessman in Uxbridge with a truck, I'll tell you what, I wouldn't be paying another excise tax in my life. Not while them trucks are sitting down there.
Well, but you would if you were a Massachusetts company. That's the whole point, is that this is not a Massachusetts company.
Anybody can rent a door in Maryland, or an office, anybody. All you need is an address.
Continue on.
David was raising his hand.
Oh, I'm sorry, Dave, yeah.
Understand what you're saying.
Thank you, Mr. Chair. Just as a point of information, the Cowan trailers and tractors are required, because they happen to be headquartered in Maryland, to pay Maryland excise tax, which is 6%, which is very comparable to what we're paying in Massachusetts. One of the reasons that they're paying it in Maryland is the fact that that's where the company headquarters are, and the nature of these trucks and trailers are they're nomadic. They go all through the New England states servicing BJ's and potentially other clientele. That's why they wouldn't be paying here. BJ's has 2 vehicles that are registered to BJ's and garaged in Uxbridge, and therefore they pay excise tax to us. But just because Cowan's out of state, they are paying excise tax, they're just not paying it to us.
Yeah, we're losing money.
Well, I mean, and I'll just note, I attended one of the public hearings when the issue came up, and I actually raised the issue when it came up. What BJ's had made a statement that we were talking about the trucks moving down, like basically the trucks coming through the center of town. And I remember distinctly the conversation that BJ's admitted that they did not own the trucks. The trucking, they contracted with third-party trucking companies. Therefore, in all intent purposes, they had no control over those trucks. They weren't going to be labeled as BJ trucks, so nobody really would know that they had BJ product in them because they were using a third party. So, I mean, to BJ's, the town knew that there was the potential for never getting any excise tax from BJ's regarding the shipping company in the process before approving BJ's to come to this location.
It's amazing what governments will do to get money, huh?
Money grab.
Okay, the Route 122 Bridge Detour, this is something that I was notified late last week. The bridge over the Blackstone River is having a weight restriction limitation imposed by Mass Highway. It's a 7-ton weight limitation. They've had a survey done and inspections, and they have a 30-day notice or a public notice. So there is a detour route that is actually going to be Blackstone Street. So Mendon Street to Blackstone, coming back down and revisiting 122. It's actually this one in red. We met today with.
Is it wide enough for the emergency vehicles?
The emergency vehicles will not, I'm sorry, the ambulance will be able to go over, but the fire apparatuses will not be able to go. So with our mutual aid agreements, the chief will have areas that are designated to other towns to respond.
The other thing is to go down Quaker Highway and come back up through Millville in the other direction.
They had another proposed route that would require going through North Smithfield, Rhode Island, and they did not get permission.
It's a good thing they just finished the new bridge down in Millville, so at least, they can come around that way.
Right, so staff met, including the school department, to talk about the impact. I conveyed some concerns. We have a new mechanism to do traffic counts through the police department. They got a grant to get this counter that also can determine the weight and type of a truck. We're gonna do a traffic count for preconditions and then post on Blackstone. Also, there's still a potential that they might be able to constrict the traffic on the bridge and have it one way so that it would bear the full weight, so there wouldn't be any weight limitation, and have a traffic signal. This is still under consideration.
They've done that in Blackstone.
And they did, and they found it to be very successful. So by November 14th, they have to have a detour route posted. And it's up to them to do the public information on it, but we wanted to put it in the town manager's report, meet with staff, and try to get the information out as soon as we get a final detour route.
So the school buses will not be able to cross the road?
Right, and so.
Do we know what the cost impact will be with the increase on rerouting those bus routes?
We're trying to put together what the fiscal impact is to leverage the repair of the road sooner. Right now, it's at 25% design. It's not anticipated to go out for a bid, and I'm not sure if it's construction bid or design or architectural plans. That's July 2010. So we're trying to get it speeded up. To answer your question, it might be a potential of having another small school bus or another bus, depending on what the full weight would be, but it could potentially be 80,000. We're in the last year of our bus contract where the school department is. So they have to work out an alternate route. The Blackstone Valley has to look at it. We also have service that goes out of town to Norfolk, Aggie, that's provided by our bus service. So there's a lot of entities that have to coordinate. But right now, if there is another bus that needs to go on, it might be potentially, I think Don and Dan, it's at 80,000, but we don't know yet.
So, and just to be clear, that's 80,000 per fiscal year, or is that?
We don't know. These are, even with me stating this to you,
Right.
we're still really in an early stage of trying to figure out what the impacts will be. The primary concern is making sure that emergency access vehicles can go either around or over. I had an email today from a local landscaping business that was concerned that he might get stuck. So if there's any questions or any concerns about the detour, they can be emailed to me and I'll forward them to Mass Highway. They need it in writing, and so phone calls aren't as effective. If we can have an email, fax, or drop off something, we'll certainly forward it over to them. But again, November 14th is their 30-day deadline to post the detour.
Just to put things in some perspective so we'll know how far we've come. In the 1830s, a 1,500-foot bridge across the Connecticut River was swept away by the spring ice that flowed down. It was rebuilt in 30 days. And we're talking they're going to have a design when?
July 2010.
No, the design goes out to bid in July.
Design goes out to bid. You can get, in fact, I have a catalog from the American Bridge Company that you go down a column and the span and the width and the weight, and everything is done. But we're gonna pay millions of dollars for a phony design. Unbelievable.
All right, a couple other things. Police union contract, we've had a successful mediation session. Both parties will seek ratification. I'll present it tonight to the board in executive session, and hopefully we'll have a recommendation for town meeting. The police department also received a grant from Ocean State for an ATV and trailer, which they could use to increase enforcement. So that's something that's hopefully will be delivered very soon, and then we'll fine-tune the regulations. I know Selectman Potaski was interested in that.
Well, I've also suggested the chief get a couple of dirt bikes. I know some of his police officers would just love a chance to ride bikes around. The dirt bike would go a bit better than I think an ATV in some of those areas.
So baby steps.
I mean, I have to ask, where's an ATV gonna go in Uxbridge?
You'd be surprised.
You'd be surprised, everywhere.
Yeah,
Well, is it a four-wheel or a three-wheel?
I don't know the details, but they still can
2
fit.
wheels,
Yeah.
4 wheels, 3 wheels, 7 wheels, no wheels.
Fire
No
chief-
wheels would be a horse, right?
Fire chief and I met with the Northbridge Town Manager and their fire chief to identify opportunities for shared services. And that's namely if there is a facility built on the Grey Rock site, if there's any potential for shared services.
If Crown and Eagle Way is not a town roadway, are there any problems driving the fire engines up and down that roadway?
They might not.
Would we then assume the liability of maintenance?
Excuse me.
I think I could honestly say that something will likely happen before the new fire station is built. And whatever issues we have to clear up with the title and everything, that will be done. Public Safety Committee met with the Whiten School PTA. They proposed a 5K road race on November 22nd. I have the registration form here. It's rain or shine. I don't expect there to be any traffic constraints or restrictions. They will have a detail officer or two making sure that the traffic is monitored, but we expect people to be on the sidewalk. It's 3.4 miles, and it's will begin and finish at the Taft School parking lot and go clockwise. There's also a football game that day, so they're working out, I think, parking the football game participants at the high school and having the other area for the pre-reg at Taft School parking lot.
Did they indicate how many they think will turn out for this run?
They did in the meeting. I don't have it with me. I think they expected it to, there was another roadways that we had in town. They expected the participants to be like the track and field and long distance runners, as also with, parents and strollers. They didn't see it to be thousands of people.
The only reason why I said that is because, I mean, not to second guess, but I can't see how realistic it is on that particular route to expect everybody to be on the sidewalk. You understand? I mean, there's parts of that sidewalk that.
There's parts of that route that don't have sidewalks.
That's true. There is that whole section that doesn't have a sidewalk. So,
So they'll put out, what I was told is that they're gonna put out cones, and so that people can either stay on the sidewalk or stay within the cones. It's gonna be laid out a few hours in advance of the registration. And, again, they'll have 2 detail officers in certain locations directing or helping traffic get by. They didn't expect a closure. Angel of Hope provided an update, which is attached to the report. They're looking to do some electrical and water connection to the site to provide some accent lighting and some security for the memorial. And they're looking into how to have water connected to maintain the flowers and shrubs.
Just the one item you skipped was the triad relationship. I forwarded an email to the board that I received from Marcia Petrella this week on that. She's very enthused about the program, so I'd like us to take that up at our next meeting as well. Just to see, my understanding is in order to join in the program requires, pomp and circumstance, and and you have the Board of Selectmen, yourself, both chiefs, GAG Lotus is involved, and a couple other people as well, and in order to kick it off. So we should talk about that.
And it's free, and it's something they made a presentation to at the senior center last week, and it's more of a proclamation where you have no ongoing commitment if you were to join. Oh, and last, this is exciting today, we got our first settlement check for the MTBE mitigation, and we got $287,892. So this has to do with the treatment for any potential methyl tertiary butyl ethyl, which is MTBE.
The gasoline additive.
This is something that most towns have thought that they would never, ever receive any kind of settlement or payment. I think it's been proposed since 2001 or 2002. So we got our first check, which is very exciting.
But rather than go after the people that mandated the additive in the gasoline, or the people who spilled the gasoline on the ground, they went after the innocent parties, because the innocent parties have the deeper pockets.
And for the record, Selectman Potaski abstained from that
Well,
vote.
keep in mind that the government mandated that additive we put in gas.
That's Mike's point.
Yeah.
If they don't sue the government,
Oh,
they don't
no,
sue
no, no, no,
people
no,
that
no, no.
built the
Government
gas
never,
station.
ever, ever takes responsibility for anything.
So I suppose ExxonMobil's gonna cut my dividends next
Yeah.
quarter because they have.
So you did abstain, I remember that.
I had
You
to
said, yeah,
abstain.
it's like, oh, I'm an excellent shareholder, that's right.
Okay, so that's my
I'm
report.
morally outraged over this one.
All right, old business, winter maintenance policy status report. Megan, gonna give us a report on that?
Sure.
What is doing it? What's this?
Following input of and the recommendations of the former DPW superintendent and assistant superintendent, of course, you adopted a policy in June regarding winter maintenance of private subdivision ways, indicating that no longer would municipal plowing or sanding be performed on private subdivision roads. The policy also established a framework by which the developers were required to submit their plans to ensure adequate maintenance. And those plans would be submitted to the town as well as to the residents on the affected streets. Unfortunately, that did not occur. None of the subdivision road owners have submitted their plans for winter maintenance. At the last meeting where I updated you on this, that was the case as well, and we discussed putting a notice on the cable and the websites, the town websites, which has been done, where the individual roads are identified, as well as the developers' names and telephone numbers, so that residents can reach them. Several developers affecting 8 to 10 roads did in fact provide direct phone numbers, didn't, ignore the call completely anyhow, and some of those are even cell phone numbers. There are about 15 roads, when it comes down to it, which for a variety of reasons are expected to constitute real challenges as we move from the policy discussion to having the snowflakes fall. Based on that winter maintenance policy and on the various Mass General laws, Town Council has been pretty adamant with staff that it's simply not appropriate to maintain the private subdivision roads where there has not been a conveyance of the deeds to the town. So even though there are some roads that are on the warrant for town meeting, that would indicate that those roads would not necessarily be maintained until the deeds are conveyed. Town meeting is November 18th. It generally takes a couple of months to get the deeds conveyed, where historically it might have been the very end of March, December, January, yeah, March. I assume that given where we are in getting up to speed with these and trying to bring some of the past to closure, that maybe some of those deeds would be recorded sooner. Nonetheless, it's certainly possible to have a winter event, certainly before November 14th. In a number of cases, roads were previously laid out and town meeting voted to accept the roads, but again, those easements or deeds were not conveyed for a number of reasons. It's certainly the developer's responsibility to make sure they're conveyed so that they are expressly off the hook for their maintenance and ownership responsibilities. In other cases, we know that the roads are in default, and in some cases, the subdivision development companies have been dissolved, don't exist. So although the maintenance policy does make provision for billing the property owners in the event of a necessary maintenance service, for example, if 911 is called and the emergency services determine that they need a plow to go before the ambulance, there's a billing process involved. In some cases, there is not a developer known to send that bill to.
One quick question, if I can jump in while it just popped into my mind. Our list does not include Crown and Eagle Way, which we discussed earlier is probably not a town road. So are we going to withhold clearance of ice and snow from Crown and Eagle Way?
Crown and Eagle Way is not listed. The Highway Department also called today with another road that is not listed, which I will research both of those. The winter maintenance policy affects private subdivision roads as well as certain private roads other than subdivision roads. So in the case where a roadway was in existence prior to 1957, which is consistent with a number of other statutes that feed into this issue, we would continue to maintain those roads. Fletcher Street is an easy example that's been discussed on many levels because of the permitting issues at hand. So again, with a little bit of legal research permitting, I could see Mr. Potaski's face.
For one, you know, you probably have to go back when Fletcher Street was first laid out. It's probably been accepted by the selectmen 100 years ago.
Well, it is on the town files as being a private way that was in existence prior to 1957. And it may be that this section of Crown and Eagle may fall under that exemption. I don't know. That will be a question for council. Again, some of this information is coming to light daily. That meeting, I believe, was a week.
Which is now Crown and Eagle Way, was there when I was a kid and probably long before that. So
And so that may be under the exemption that would support municipal.
Crown and Eagle property at that time. It was a private driveway.
So that's why we've got to do the research. It's not such an easy question.
I'd like to throw out a thought, right where and I think I kind of touched on it last time you gave this presentation. It seemed, just kind of looking at this in the sense of a new member of the board, it seems like there's too much. We're setting ourselves up, and the developers and the buyers of these residents for, in not all cases, but it's seeming to be that, the roads are not getting accepted when people have been living in these homes for 2, 3, 4 years down the road, and they may not be aware of this necessarily when they buy a home. I would go back again to why can't, before they can build the first house in that subdivision, they've got to have the roads laid out, accepted, and that has to be done, or you cannot break ground on one residence.
That's the premise of the subdivision control law, and that's the manner that subdivision laws are implemented throughout much of the country. However, the next clause of Mass General Law, Chapter 41, Section 81, is that in the alternative, the developer has the right to post surety in a form and amount adequate, deemed adequate by the planning board, to guarantee completion of the construction of the subdivision infrastructure. None of those statutory provisions that I'm aware of, and of course with town council here, I would invite Pat to step in, but none of the provisions that I'm aware of compel conveyance of the actual ownership of the easements and roadway or the easements across them for the roadway and for the drainage, as well as sewer and other infrastructure to the town before before a lot is built. I've worked in other communities, and one of the objectives that I'll continue working toward here is that when there is a lot released by virtue of a developer posting surety in an adequate form and amount as required, I've asked and been successful at having the developers, I want to be careful about using the word convey, provide signed documents that can be held in trust, so that in the event that there's a problem down the line, maybe we've saved ourselves 3 to 5 years of legal challenges and headaches in getting those conveyances to the town. Maybe we have the instruments available. It's not always the case. But again, it's the constraint of the statutes.
Okay, so if I understand what you're saying, it's mass statute that, and it's possibly only the state of Massachusetts who has this type of statute that allows the contractors to convey?
I haven't researched throughout the country. I know from experience in a number of other states that there is not a provision in all states whereby surety is posted in order to allow the conveyance of lots while the subdivision is still going on.
So it's not a situation where we can put in a bylaw that specifically for this town, that you have to put the road in, and you have to follow, like you said, maybe put the deed in trust because it has a direct impact on the town down the road. If in fact something goes wrong, then it costs the town years and money, and then the taxpayers or the residents of the town additional costs because the road is either accepted or not accepted, and it opens up this avenue. I mean, You understand what I'm saying? From a financial
Absolutely.
standpoint, is there anything the town can do to try to avoid the litigation down the road on this matter?
If I may, I mean, as Megan's indicated, we do have specific statutory provisions under the Subdivision Control Act that allow a developer to provide surety to the town in lieu of completing roadways before it can sell lots. That's a mandatory requirement. We can adopt subdivision rules and regulations that are consistent with law, but to the extent they're deemed to be inconsistent, i.e. taking away the right of a developer to post that surety and requiring other hard performance, it would likely be subject to challenge, in my view. I do think that if the planning board and enforcement officers are very diligent in staying on top of making sure the security amounts are adequate, making sure that work is completed in accordance with the schedule approved with the subdivision approval, that it does work. It does take a lot of work. It takes a lot of effort. And I think the issues that I've been working with Megan on over the last year or so are years and years and years in the making. I mean, there's been a lot of different practices in the town, or lax supervision and oversight of these subdivisions.
And that's it, and that, this problem is not just snow removal. I mean, it's, how do you get roads finished where the developer is no longer in existence, that there's not enough, surety on hand to do that? For someone who wants to continue to develop in this town, you've got some leverage because, oh, well, how can we give you another permit when you've not finished that existing development? But where that, luxury doesn't exist in many of these situations, we've got to come up with another solution here. I'm open for suggestions, but we've got to find a way of making sure that these roads get completed, accepted, on the rolls, because I mean, we get more highway money too once we've accepted the roads as well. I mean, so if right now we're providing services, or have been up until this year providing services, that we've incurred liability while we've been providing those services, and we've not been compensated by through highway funds. That's a problem.
I mean, right, and the additional liability, I mean, I would ask, I mean, not to open a can of worms, but from a liability standpoint for the town, I mean, do we have school buses going down these roads that are in fact are not even considered public ways?
That's always an area of concern, and actually that was discussed today, but the school department very closely monitors the list of public and private streets that's been produced by DPW. Now, historically, following town meeting action, streets were sometimes moved from the private list to the public list, and with the increased coordination through the town manager's office, working with the different departments, and with the additional work that the Board of Selectmen has taken on just by investigating, let alone adopting the maintenance policy, and the additional efforts of the planning board to get their arms around these outdated projects and try to move them forward, you're seeing the fruits of that. It's, as council indicated, many, many years, even decades in the making, but from where I sit, and I can probably see the light through the tunnel a little bit easier than many because I'm working with it, but certainly I think we're coming to fresh air. We're moving toward closure through communication. We've been able to get some of the deeds provided by developers, even though the projects are long gone. But the developers haven't dissolved in some cases, so we've been able to work with them and get deeds conveyed to the town so that those are ready to go. The greater challenges will be in the case where the developers have been dissolved, and it may require eminent domain takings, and that's part of the overall completion process that will estimate remaining costs and timeframes and tasks associated with the projects.
But the next one that we're going to be looking at, there's a company that's got a subdivision moving forward and has acquired a license from the state to build another bridge over the Mumford as part of the subdivision effort. And the license from the state requires a commitment to 30 years worth of maintenance and upkeep of that bridge. Now, if the town then takes over the road on either side of the bridge, do we presumably get the bridge and also the responsibility for the maintenance of that bridge? And I've had a couple of emails with Megan on that, and it's up in the air at this point.
Or is the builder required to put in a surety to cover the maintenance of the bridge for 30 years?
That's the question I asked me, and that's something the planning board's gonna have to look at. You know, if they're going to agree to this subdivision and this bridge, who is gonna be repairing that bridge 25 years down the road? Because the developer has a license requiring the development company to do that maintenance. And, you know, they may finish the bridge, turn it over to the town, and dissolve the next day. And there won't be any development company to go back to when something falls apart on the bridge.
In that particular case, my understanding is that the license was reached or agreed to at some point after the permits were issued by the planning board. I have not to date received a copy of that, so I don't know what it looks like. I don't know who the interested parties are, who those license agreements are between. So in terms of the permitting process, the surety that is provided for under the statutes of Chapter 4181, being the subdivision statutes, surety is related to completion of the project. It's expressly not related to the maintenance of infrastructure, and that's one of the other provisions of the policy that you adopted in this past June, is that moving forward.
Until this point, having adopted a policy, we haven't until this point come up against the notion of a 30-year license, a license for a bridge that requires a 30-year commitment of maintenance on that bridge.
And beyond that, your maintenance policy generally calls for provision of a maintenance surety to be posted associated with subdivision projects. So again, 4181 is not surety.
Hopefully, when the planning board and others look at this in detail, you know, they go a step further and do some over-engineering of that bridge, just as a way of building some hopefulness into it.
You know, we're getting off topic here.
Yeah, we are.
on that, but,
I'm sorry. Okay,
So
go ahead. We're
as
doing
we-
winter maintenance.
As we look to do the final, as we look to do the final updates of the list that's publicly available on the website and the cable TV right now, in some cases, as I said, development companies have been dissolved, or we don't know who the developer is, and we'll add a statement encouraging residents to get together themselves because they have some maintenance issues to address, and if they can band together, get an economy of scale going and perform some maintenance, at least there won't be that kind of panicking.
I've been giving some thought to this, too. Is there any vehicle by which the town could provide a for-fee service to whatever residents associations or the case may be, so that, just as a matter of course of plowing the public streets, that we could still plow the private streets, but essentially under contract, do it at cost. You know, I'm not suggesting that the town is gonna get into the snow plowing business to try to make money, but if there's a way we could, you know, I guess, to still get these roads plowed, without, you know, incurring any cost or liability, and have that paid by the residents, that's probably be more cost-effective than them going out for someone who has to make a profit on it.
I know I'm standing at the podium, but I think that's most effectively tackled by town council.
Okay, as a general matter, let's take this issue down to square one.
Yeah.
There are public ways and private ways.
Yeah.
Private way is private property. As a matter of law, town should not be spending
Yeah.
money to maintain or repair
Right,
private
right.
property. That's what the whole public way acceptance process is all about.
Certainly.
There is a provision in law, Chapter 40, Section 8C, that allows towns to appropriate funds on an annual basis to maintain and repair private ways. So there is a vehicle that gives us the right to raise money to do that work without, in my view, imposing on us the liability and obligations that go with maintaining the public way. And I'm assuming that statute was adopted to address the very types of situations we're talking
Right,
about, where,
right.
for the benefit of the citizens of the town wants to provide that service. I would suggest that's up to your discretion as a Board of Selectmen, whether or not to appropriate and use town funds for the maintenance and repair of private ways.
That wasn't the question. The question was, can we do it as a service to the citizens?
No,
Can we pay us for it?
Well, I don't
Right.
think you can provide public services for private property beyond that appropriation of funds, no.
Well, how is that different than individuals paying for daycare, for the daycare that's being provided by, they pay I mean, You understand?
that's a
I
good
mean, the
point.
daycare's occurring in the town building, and it's in connection with the school, but yet the people are paying for that service directly, the townspeople aren't. So I guess my, that and the lunch service, I mean, those are examples where, they are.
And the ambulance
they're-
service.
And the ambulance service,
Ambulance
right, they're all being provided by town employees, and people are paying for those specific services.
Right, because they're paying for a service that the town is rendering.
Wouldn't this be
Well,
the
it's
same
the same
thing?
thing.
They would agree to pay reimburse the town, so every time that town truck goes down their road, they're gonna get a bill for that plowing.
They would argue they're already paying
Yeah.
taxes like the people that are getting the street.
Yeah, and our contract rates are
But
competitive rates.
that's a separate issue.
Yeah, right.
The question was, could it be done?
Could it be
And I
done?
don't know any reason why it couldn't be done. I'm not saying it's,
It may not be cost effective
Right,
for
right.
them because the rates that we may, like you said,
Charge.
the rates that we may charge may be higher than
they could do themselves.
they could do
But that's-
themselves
That
or
may be the case,
hire
but,
an
I mean,
independent
we don't
contractor.
need, we don't have the profit margin tacked in. Anybody else that is gonna do it is gonna.
Who would you bill for the service? The residents?
You would
Yeah,
bill
you,
us. You would ha-
Street association,
Well, how I
condo
would see it
association.
is, there's 8 houses, I mean, this is how I would see it, 8 houses on the street. The town sends all 8 houses, all the homes on the street have to agree, or the service can't be conducted, unless 6 of the houses agree to pave the road for all 8. But you understand what I'm saying? They have to agree that the bill will be paid. And then, if there's 8 homes on the all 8 agree that they want it paid by the town, and they all agree to, the cost will be X, let's say $200 every time the truck goes down the road. And then you take and you divide 8 by 200, and they're each set an individual bill. If they don't pay it, then it would be treated just like any other, they could get a lien assessed, or the same thing, if you don't pay any other town bill, but it's handled that same way. Now, the only burden I see is that the DPW will have to go out and assess what's the fee to be associated with each road, because each road is a different width, it's different lengths, so it's not gonna be one
Yeah,
fee.
I'm just trying to come up with a creative solution, though, that
Right.
solves
And
the
it could
problem.
be,
Because, I
right.
mean, quite frankly, the fact that a lot of these are in the state that there are is, because either the road wasn't accepted properly, or not enough surety has been held, or whatever the case may be. I'm just trying to find a situation that works for everybody.
What we have to watch out for is, if there is a problem purely caused by the town, that's one issue. But many times, the people who bought these properties knew they were private roads.
Sure.
And so forth. They have to bear some of the responsibility. People should be more leery when they buy something in the development to make sure exactly what status is and what's going to happen.
Some of the roads, the status of the road with raised manhole covers and others provide a hazard to our equipment and the roadway itself. And I'm not sure how many of those roads qualify under that.
I didn't want to detour, so I just
Yeah.
wanted.
But it leads us to
Give
the
thought
next, we did get a comment from developer's attorney, Attorney Hogarth, for Mr. Hutnack, who has noted that it's not his responsibility to plow any of his developments. And so, I don't know, Pat, if you want to talk about that.
Sure, she has raised the position that because the town has adopted Chapter 40, Section 6C, which authorizes us to appropriate funds for repairs of public ways, we have, in effect, taken over responsibility and control of those ways. I disagree with her 100% in that proposition. The only way we acquire full responsibility and control of ways is to accept them as public ways in the town and acquire the interest, so.
The statute allows the town to
Correct.
do those
And
things.
yeah.
Doesn't require the town to do
require
those things.
Correct. And when we do those things, the other issue to be wary of is, with public ways, there's a limitation on liability for any property damage or personal injury that's caused. It's limited by statute. That same limitation doesn't
Not
apply
exist
to
for private,
private ways.
okay.
So if we were to, God forbid, injure someone
Yep.
or a property on a private way while doing this, our liability would be the standard negligence standard, which is a $100,000 cap rather than a $5,000 cap that relates to public
Okay.
ways.
Okay.
Guess that's it.
All right. 20 after 9, we still have a number of items to get to. I'd like to kind of get a sense from the board as to, your pleasure as to what you feel is most important to address this evening.
It would be helpful if things like the town manager's report, because we get a written copy of it generally, rather than reading the whole report, just respond to questions if we have any questions, because a lot of the stuff is just a summation of things that went on.
Can I recommend that we accept the minutes, because we have, those were continued over from 10-6, so that's at least one thing that we should knock off the agenda.
All right, I believe is Attorney Lamar here for item C.
I think he's here for item B, fall town meeting warrant. Jerry?
What are you here for?
Wake up.
Okay,
Oh, that's why you're here.
okay. Okay.
Is that gonna come up?
It's in the meeting warrant.
Right.
We're gonna get to that.
Well,
I have to sometime.
Two others in the audience.
Is that zoning then?
also for the,
I don't know. Steve, warrant articles or the,
Lou, you here to address anything? Okay. Okay. All right, then why don't we jump into the next agenda item, which would be the fall annual town meeting warrant. Get the copy on the table.
yeah.
Are we gonna go straight to that article number?
Let's,
The question was asked of the chair.
yeah.
Yes.
Yeah, I
Okay,
was
just so I
actually,
know which page I'm at, that's
well, yeah,
all.
I just want to kind of take a survey, like, who is here is for which articles in particular?
So your Article 39.
39, Jerry? Okay. Right, Article 39 is the citizen's petition to amend the zoning bylaws relative to electrical generating facilities. We had been going through most of the board-sponsored articles at our prior meeting, and now we're going to get into some of the petition articles. So really, I guess, want to open up for discussion from the board.
Mr. Chairman, I'd first like to start just by, I've read some of the newspaper articles recently regarding this, and the last time that we discussed it, there was a motion on the table to actually move this from a citizen petition to actually a board-sponsored.
Right.
And I just want to reiterate, I guess, my personal position on this, that I see this strictly as a bylaw issue. This is not any one particular power plant sponsoring this or the town entering into any deal with one particular power plant. I personally have looked at this this is a bylaw issue, to look at whether or not the town wants to open the option for power plant to come within this bylaw, and then I would take the position that it would then be, at the appropriate time, the board or other town officials' job and responsibility to then put out to bid or to solicit offers from any company that would like to come and do business in Uxbridge, and we negotiate the best possible situation for this town. I just want to make that.
Is that before or after you change the bylaw?
If the bylaw is in fact accepted.
Well, if the bylaw is accepted, anyone, as a matter of right, if they comply with the bylaw, they don't need to come to the town and say, may I? That's what bylaws are for.
No,
And we don't have to put it out to bid, because if it's being developed on private property, we can't put it
no,
out to bid.
no.
Well, no,
Right, I understand that.
there is a scheme under Massachusetts development procedures, and I wish Megan was still here, where the town could act, we could act, especially if we consider the reorganization and have the Director of Planning and Economic Development work for the Selectmen, we could go out under one of the particular provisions that they have in development, and we could instruct the Director of Development, Planning and Economic Development to work with property owners to proactively or anticipatorily go in for rezoning of property, go in for the permitting process, the planning process, the permitting process, and we could direct the Director of Planning and Economic Development to have a complete package in coordination with the property owner that we could then take to town meeting, get approval, and then go out in coordination with the property owner and market it. That's allowed under part of our, and we're not doing that, we're not working with property owners.
Well, that would be allowed, you don't need a special law to do that.
It's there, it's already there, and yet we seem to be dodging
But
that.
you have to go and find some property owner
Yes.
who wants to throw their lot in
Well,
with a town, and a person would have to be insane to do that.
Well, I mean, that's.
I would take issue with that.
Yeah,
Severely
I would
disturbed, mentally disturbed.
The reason why.
Very trusting of the Board of Selectmen, yes.
The reason why I bring this up there was a particular newspaper article in the way that, and this is my interpretation of the article, but it was like, this particular company is coming, this is the power plant that this town is going to get. And I guess I take offense with that because I don't want people to, again, when this article hits town meeting floor, to go, what's the price and how much money are we getting? I want to make that very clear that there is.
That's not what the company said, but the people said, this is what you're gonna get. They said, this is what we would like to do.
Okay,
And-
and just make it very clear that there's no, we have not met as a board and even made any determination that this is the company that would be coming, that, we're only going to consider this company. I think that it needs, the citizens need to know that.
Anybody said that.
Who was the we?
It was just a bylaw change.
And I just want to make that clear, that it is strictly a
Your opening
bylaw change.
comments were spot on, and I think almost really all we need to say is, this is a bylaw change that opens the town to receive,
That was said last
Thank you.
time.
No,
And
I understand.
poor Harold Clyde tried to make that argument, but it doesn't work, because people know, in fact, the reality is, a particular developer wants to put a particular power plant on a particular piece of property in Uxbridge, and that's why they're looking to change the bylaw.
And that's
And
why
under
I
your theory-
recommended
under
that
your
this
theory,
be.
people are gonna say, well, gee, that's great. You go out and find somebody who wants to do this, and then come and ask me to change the bylaw.
Yes,
Well,
and I
we
think
could
that
do
that's
it
very
in a-
fair.
In a more proactive way and work in conjunction with the property owner to do, the anticipatory rezoning, the anticipatory planning and permitting, and then go out and say, okay, Uxbridge is open for business, and here's one of the opportunities we have for business.
So
He's
you're
here.
saying you're gonna change the zoning in advance?
Yes.
And then go out?
And
Well,
then go to planning
Yes.
and permitting and get
if
the
you
whole
go
package
back
together.
and if you change the zoning, and I'm not part of your in-group, I'm just a Joe Schmo someplace, I say, oh, Uxbridge changed the zoning, gee, I know a fella has something, I'm gonna go and see him, I'm gonna do this. You can't exclude me.
Correct.
That's right.
So what are you accomplishing? And why would you do that if you already have somebody that has done
Why?
all
Because
that
it's
they wanna
called
do?
competition. Unofficially, this is not the only player in town. It is healthy to have competitive bids. Isn't that why when the property is we put out an RFP? Because we want to see how many options we have.
And if you want to buy something, you are perfectly free to go out and get competitive
That's right.
bids. But you, nor I, are in that position. The person who owns the property is the one to do that. They're free to get competitive bids.
And absolutely, but we can approach them as the town and say, you know, we heard your
You
property.
make the customer you have.
Right, we're going to
Team
assist.
up with us, and we'll do a better job. And we can say, you know how good of a job we did, just look at what we did on the Douglas Street land. I mean, who wouldn't run to us?
So we have a
Do we
proponent
have a
here.
motion on the table, or do we not? You said we had a motion on the table from the last meeting? that
No, no, we
Did
didn't, we voted in it, right,
Okay.
that was my, right, back on, right, there was, right. I put the motion to move it from a citizen petition to a
So
board
the
position, to have the board take
question
it.
before us tonight
Right.
is, does this board support this
Exactly,
citizen?
as we've
Correct.
done on all the other warrant articles, weighing
Right.
in on this board's support of this citizen petition article.
Correct.
I move that the board support Article 39, a citizen's petition to amend the zoning bylaws relating to electrical generating facilities.
I'll second that.
Any further discussion?
Yes. I would be happier if we just removed the prohibition, but I'll support the motion. I'll vote for the motion. The prohibition will not stand a test, and I don't believe in
Right, I understand what you're
bad
saying.
government.
Right.
Any other commentary? No? Call for the vote, all in favor?
Aye.
It's 5-0.
Okay, so there's a lot of talk about the newspaper article. So we have no proposal, there's no application on file. This, all we have is a petition to amend the zoning bylaws. That's it for the record.
That's it right now, yep.
Thank you.
That was easy.
All right, where did we leave off? Let's see.
Yeah, we left off on 28, 29, somewhere in there.
So I believe you were holding your first few articles because they were financial articles.
Right,
Correct.
and we're waiting for
Okay.
the numbers to be
And we're
finalized.
still,
Right.
we're waiting for numbers and certification of free cash.
Right, okay. So we have Article 9, which was the street acceptance for Big Rock Road.
And we voted to take no action.
Okay. Do you still want to wait?
Well, we were waiting, we took no action because we were waiting for a recommendation from the planning board, correct? The planning report, and they've done that report now, correct?
I
So
believe the
therefore, we can
motion's
take
okay.
action, right? Was their report favorable?
Yes,
On which one?
Big Rock.
Big Rock.
Big Rock,
Big Rock.
Article 9.
Right, it's one we voted on earlier.
I was just looking to see if there was, I don't think there were any issues.
Yeah, right, that's one.
Yeah, that's the
voted
one we
to
did
lay out.
earlier.
Voted to lay out earlier, too.
Right.
All right, do I have a motion?
I move that the board accept or support Article 9, the street acceptance of Big Rock Road.
Second.
Any discussion? No? All in favor?
Aye.
5-0.
Article 10 is the purchase of the Hutnack well land. I wasn't sure if the board wanted to go into executive session or not. Hutnack has responded to our offer.
That doesn't need executive session, I don't think.
Any concerns?
You're gonna be talking about the value of property that would qualify for executive session, but it's your decision whether to go into it or not. You don't have to.
Well, didn't we already have
About the value of the property, because
he made a presentation to us and we've already discussed it in open session.
yes, but then they've made a,
So they made a
went back to it.
counteroffer?
So what's his response to?
they know what their counteroffer is, and we know it because we received it.
Right.
So letting people know what that is doesn't compromise the town's position.
All right, so it doesn't matter that they deem it as executive session, it's up to your board. Do you want me to read the letter?
Yes.
My only concern is that I want to make sure, because I'm not going to vote on the issue because I'm not on town water, that people understand what it will cost and what the benefits will be or may not be. and what the ramifications might be in the future if they don't buy it and then something happens to some of the other welfares. That's all. The decision is up to the people who are going to be paying the bill.
And I agree with you, and on that note, I would also want it to be very clear and spelled out to town meeting, that the CIF rates that they're currently paying are not inclusive of the debts that are additionally coming, that there's 2 more debt instruments that are gonna hit the CIF before this would even hit the CIF, and that those figures may be made available so that people have a full impact of what their CIF would be if in fact they voted on this. And I would also additionally throw out, which didn't come up during our last discussion, that there's always, because we had discussed that basically this well would possibly not be used for 15, 20 years down the road. At that point, even if we passed on it, that well will still always be there. And 15 to 20 years down the road, there still is an option that the town could go back and take that property by eminent domain.
Not if it's developed. That's the issue.
They can buy the houses back and knock them down and turn it back into a well field. I mean, come on, you realistically could do that.
I suppose if the federal government could do that, I don't know if we have the pockets to do that.
You know, and who says that the law may not change 15 to 20 years from now, you know, requiring that, you know, who knows, you could possibly be able to drill a well field with houses on it. You don't know what the laws would be in 15 to 20 years, is all I'm saying.
It's certainly true, we don't know that.
Anyway, what are they?
Yeah, so what's the
coming back
price?
with their counteroffer?
So if they declined our counteroffer for the Wellfield property, we had offered them $275,000. He's willing to accept $500,000 in cash or $600,000 over a period of years receivable in the form of a municipal bond. And he notes, I suggest that we arrive at a cash figure first, then discuss a method of payment. This is Attorney Cove. I wish to emphasize to your board that the Hutneck site is unique in that it is the only site that is currently on your water distribution line and is within 1,000 feet of 3-phase power to energize any pumps that need to be installed on the site. The presence of this infrastructure is worth between $400,000 and $500,000, separate and apart from the cost of the well site. Additionally, few, if any, other sites of this nature are left in the town of Uxbridge, and this may very well be a last opportunity for the town to acquire a well site situated as conveniently as this site. And please let me know of your further proposals please let me know your further proposals at your immediate convenience.
The figure you mentioned is not the same as my information.
Isn't that the same that he offered us that evening? So he hasn't changed his position?
No,
That's not.
It's the exact same thing?
Yes, that is the same, but that's not my information.
Well, we have to go by what that letter says.
What's the date of that letter?
October 23rd.
Well, that's very strange.
23rd.
The problem is, you look at that cost in terms of what it costs per gallon per minute and what it costs per acre of land that he's selling us, and this is twice what we're paying for other well fields.
Right.
So why would we want to be, you know, Cove
Much less than what we paid for the Burnett mill field.
Well, that was Cove's argument. It's less. Well, yeah, so what?
Well, both that has to do with both sides, so what?
Right.
I'd just like to say, I want people to know what the CIF would be.
Right.
I don't want this to come back to us again like it has before. Oh, what's this on our bill? Let the people know right now, before they vote. If you vote for this, you're gonna vote for your CIF too. And I understand that's the reason Peter doesn't vote for it. He doesn't have town water and sewer. But I'd like to say right up front, have Dave come up and tell us what the CIF for this would be.
Well, no, what are the 2 CIFs that have not yet appeared on the bills? That people are gonna be rioting in the streets when they see them, what, next quarter?
Right.
Or the quarter after?
No, they haven't been borrowed.
They haven't been borrowed.
No,
One
but
is
the
the
potential,
Yeah, one is the Connosson well field, and we've submitted a grant for that acquisition, so that wouldn't be a CIF if the grant's approved. And the other is the.
but if it's not, we still need to have the figure available.
Or we negotiated it as our mitigation for any potential power plant that might be located right now.
And that's a good option also.
Yeah, the other authorization is $1.5 million worth of water improvements. That has not been borrowed, and will probably go out once we have a new DPW director in place and we firm up a schedule as to when that money will be needed. It'll be going out eventually, but their town meeting has authorized it. So that'll be another CIF that will be coming on.
And didn't we, at the last meeting, kind of roughly estimate that one at somewhere, like, wasn't it $70 to $80? Wasn't that a kind of?
Approximately. I can run a quick scenario and get back to you in a couple of minutes with figures if need be.
And, you know, we need not be bullied into this with the claims that if you don't buy this, you know, strategically, you're gonna run out of water in the future. We have an existing link that we can simply turn the tap and start buying water from the Whitensville Water Company.
Well, and as I also said, we can always come back. I mean, I know that it's not always been an attractive, but it's still an option. We can always go back and take this by eminent domain. And frankly, in 15 to 20 years, it could be cheaper for the town to buy up the 6 or 7 houses that may or may not be built on that property at that time. Or just drop the well with the houses there, you know, I mean.
My take on things like this is, we have twofold responsibility.
Right.
Here as a board. One is to provide for and plan for, you know, the future well-being of the community, right? The second, though, is clearly to be sensitive to the tax burden on the existing members of the community. You know, and I personally feel that, and I'm not on the water system, okay? I tend not to abstain from these votes, but I am not on the water system. But I do feel that there has been, that the town has made a significant amount of investment in this area, all well spent and good investment. But at this point, I'm not personally in favor of this article, just because of all the additional investment we have made in the infrastructure improvements in this area. And again, I'm speaking from, you know, I've got, you know, well water and septic, so I'm not a user of the systems, but I'm sensitive to the financial, you know, challenges that everyone's faced with right now. I can't justify the 15-year view with the 15-day view right now that, you know, people are feeling in their pocketbooks. So I personally am not in favor of this, but I mean, I don't know. You know, we should have a motion though.
You want to do a motion?
Yeah, I move that the Board of Selectmen not support Article 10, the purchase of the Hutnack well land.
I'll second.
Okay. Any other discussion at this point? All in favor of not supporting, which is kind of a negative motion, but it is a negative motion.
It is a negative, yeah. Aye.
Aye. Peter, are you saying?
I'm not abstaining.
Okay.
So it's 041?
No, it's
Recommendation-
401.
Recommendation of the board
Okay,
is
it's
041.
Oh, that's right. Well,
Yeah,
It's
exactly.
unfavorable.
no, it's a favorable for
an
not,
unfavorable
so it's
recommendation.
401.
It was an unfavorable recommendation.
Okay, unfavorable.
Recommend disapproval.
Yes.
So it's a favorable. Did we do that totally backwards?
No, you did it right. You did it
Okay.
It's an unfavorable recommendation. It was a 401 vote.
Oh, I see what you're
Unfavorable
saying.
recommendation.
Okay, okay.
Are you enjoying yourself, Howard?
No, as a matter of fact, I'm not.
I'm with you, Howard.
I might even use the appalled word.
Okay, so that gets us to Article 15, appropriation to
We
fund,
did 11, right?
yeah,
Okay.
11, the Mass Electric
15,
Company
okay.
easement, that's
Yeah,
for
15.
our own water supply. Yeah, so 15 is the feasibility study. Presentation was made last Thursday to FinCom.
Any discussion from the board?
Yeah, I never got what I thought was an acceptable answer at the Finance Committee meeting as to whether or not a appropriation for a very narrow and specific purpose can actually be spent in a broader sense. In other words, they claim they're going to examine such things as renovation, examine such things as building an extension on the current building. They claim they're going to do this under this article, but the article is very, very narrowly and specifically crafted as to say, we're only going to look at building a new school on a specific piece of land.
And may I, Mr. Chairman, on that point, I strongly recommend that the motion be run by the MSBA up front. I've seen other situations where failure to include considering options type language has been deemed to be inappropriate and disqualifying for.
That was done already.
In actuality, this has been done.
Yeah.
Okay.
And the answer is, you know, this is what the MSBA, well, we don't know what question was asked.
Right.
In other words, if the question was asked, how do we frame an article for the specific purpose of doing a specific property on a specific piece of land, and this is the type of wording that we need. In other words, I don't know that the question was asked of the MSBA, well, how do we frame an article that will allow us to do a feasibility study that will include either remodeling the existing school, expanding the existing school, or building a new school? I don't know how that question was posed to the MSBA. So whatever question was posed, this is the answer they have.
Well, the term feasibility study typically, as a term of art, does mean to consider all options relative to a proposed project. But the interesting thing here is it does say relating to the construction of a new high school.
Yes.
And the address.
Yeah. If it was related to the requirement for a new high school in the town of Uxbridge, that would be a more broader way of framing this particular question.
That's a very good point, and I agree with you. Can I ask that we put this off and ask for a definitive answer from the school committee or the superintendent, the business manager, because that's a very important thing. Because throughout this process, we've been told that we're going to look at, to see if you need a school, we're going to look at renovations and so forth. But as you point out, that's not what the article says.
Right.
As a point of information, the Finance Committee, in fact, asked those very same questions.
Yeah.
And the assurance from the school committee is, oh yeah, that includes all that. And there is a document floating around someplace where the motion that was approved by the MSBA as well as the article language was approved by the MSBA is exactly the same, and it says that. So I think if you check with the school committee, what the answer you will get is, oh yeah, it includes the whole study.
Well, if it includes the whole study of things other than the school, then it has to say it here.
Right, then why didn't they phrase it that way?
Because
That's why the question
I asked
came
that
up.
yeah, because I don't think that this article, as worded, would allow for that. Somebody has to prove to me that it doesn't. It's like I got a loan from a bank one time, and a note, and they said, well, it was a 2-year note, but I read in the fine print, it's callable. I said, what about this? Oh, we'll never do that. Oh, good, I'll cross it out. Oh, you can't cross it out. Well, then you might do that. Oh, no, we'll never do that. Then I'll cross it out. But I agree. Just let's let's go.
Because we-
That's
right.
going to come up, and there's nothing that will kill a deal faster than a legitimate question that hasn't been properly addressed.
I asked that question at the Finance Committee that
Right.
night. You were here.
And they said
You were
that
there,
they
Kevin.
had asked, in preparation for the Finance Committee meeting, but that they would ask the question again with proper framing, because, the concerns about the specificity of the
The school
motion.
building authority may have that view, but the Department of Revenue may have a different view.
Well, that's a good
The
point.
town accountant may have a different view.
But there's also nothing to prevent the chairman of the school committee from offering an amendment to this to offer broader language at town meeting.
Yeah.
Right.
The challenge being, though, was will the MSBA...
They have a month to ask the MSBA for
No,
wording that
I
accomplishes that
understand,
purpose.
right,
So if they come to town meeting without alternative wording for an amendment, it tells me that they're not interested in doing anything but building a new school.
Now, typically, a town meeting article, you can do less than what's authorized. You can never do more than what's authorized. I mean, just kind of a general rule of thumb. So one could make the argument. Yeah.
That's really at the judgment of the moderator.
Right, within discretion, right.
controls it.
Right, but you clearly can do less.
Yeah.
And one argument I have heard is, well, if what's being asked for is the whole kit and caboodle, which is building a new high school on new land and all that, certainly, if we're supportive of that, then we should be supportive of either doing nothing, which is one of the options, remodeling or leasing space, which are the other options.
But that's not the issue. The issue is,
No, I
this
understand.
authorizes the expenditure of funds for a specific
Right,
purpose.
right.
And we can't change the purpose of the funds.
I'm just sharing,
After the
with the
appropriation
board
is
other
done.
arguments I've heard, though,
Yeah.
which are, that the other items are a subset of the big picture. What they're asking for is the big picture, and everything else being smaller
We
in
may
cost.
have authority to buy 2 dozen oranges, but when we go, we see there's only 1 dozen good, so we buy only 1
Yeah,
dozen
right.
good, that's okay.
Right.
But you can't buy 3 dozen.
All right, should we hold off on this until, okay, so that,
Can we request specifically then that the chair of the school building committee address this issue? Or are we gonna be
I know
asking
as a
specifically
result
the
of
school committee?
Hearing that they were, again, going to follow up and frame the question appropriately, I think, so we just need to just check
Okay.
on that.
I wanted to note, I forgot to my town manager's report, that Jim Haynes has resigned from the school building committee, so we'll have a vacancy. I think he was appointed as a general public representative.
He was initially appointed as a school committee member, and then when he decided not to seek reelection to the school committee,
Right.
we made him a citizen appointee. Okay.
Yeah, so we'll put that on the next agenda.
Okay.
Okay, so,
Actually, I just want to call timeout. It's about 5 or 10 minutes to 10.
Excuse me.
We'd agreed to kind of do checkpoint a little before 10 to determine the board's pleasure as far as conducting additional business this evening, or?
Well, we need to get to the minutes, so, and there are lots of them.
Okay.
Although I have some things I want to go over, but I will wait for the next meeting.
I do need
Any
an
other
executive
meetings?
session tonight briefly,
Okay.
for the police contract.
Okay. Any other thoughts?
Well, I mean, you did, prior to this meeting, you did say that this would be possibly our last late evening. You know, we have that rule, but you also kind of set us out a warning that it was going to be a late night. So my concern is just that if we push too much from this evening and maybe don't have one more late night, so that we can actually start fresh and move on from that point.
Well, I think we have 3 things here that we probably, people may want us to get to, is the proclamation of American Indian Heritage Month. That'll go quick. The hot dog cart, that should go quick. And the Class 2 license business name change, that should go pretty quick, shouldn't it?
Yeah, we could get those done probably in about
the election
7
warrant's
minutes.
gotta be
right?
done.
See the back of that.
Yeah, and the election one has been done, yeah. So we could probably do those 4 very, very quickly.
Let's try to knock those 4 out.
And then go into executive
And
session.
then I would like us to pull out our calendars and maybe let's schedule one catch-up meeting for
Okay.
mid to late next week, Wednesday, Thursday next week.
Okay.
Is this a possibility? And then really target, the 3-hour, schedule moving forward.
That meeting next week, let's just do the stuff we didn't do tonight.
Yeah,
Okay.
yeah,
Okay. Okay, that's good.
all right.
So.
So let's move to,
Indian Heritage-
under new business. Actually, is there anything we need to weigh in on the
Yeah,
deed restriction?
Look, Pat, were you able to touch base with Attorney Lemire about the deed restriction at Douglas Street?
Excuse me.
Sorry.
All right, so the next step would be for the board to approve the deed restriction. You would forward it to them. Then a closing would be scheduled. I think, what's the timing? We talked a little bit about this before.
Didn't they have a timing or something?
Well,
They're waiting for a
They have another
PNS?
PNS, but financing may or may not be an issue. I'm not sure what the deal is. I'm assuming if they can, the funds are readily available, we could probably have it done within 2 or 3 weeks, I would guess.
So they're waiting to issue the PNS, or?
No, they have another PNS with another party that
Right, but they're waiting to execute. What I'm saying is, they haven't officially signed that PNS because they're waiting for the deed restriction?
no, they've already
Or
signed it.
they're already in that
They're in
PNS,
it.
and they're possibly
correct.
extending
I
closing?
think they've already extended it,
Yeah, they have.
actually.
With another party?
I believe so, yeah.
So, you know those nice colored brochures? Throw that set away, because there's another set of nice colored
No, I don't think
brochures.
that's the case. I think the other party is.
No, they're saying just the other party, not us.
Same.
The other party besides us, not the
Besides
other-
us.
Oh, that is party, okay.
Okay. All right.
So those brochures are still good.
So then, next week, we will just take a pass through that and
I mean,
approve
we're not
that.
going to have counsel here. I have copies on, should be on your desk if you want to ask any questions. I think it's,
Of which, the deed thing?
yeah,
Yeah, that was on the desk.
okay. Was that thing marked first? All right.
Yes,
This one.
Want to go through it?
Sure, I'll be happy to.
Walk us through it real quick, if you could.
What we basically have is there is a deed whereby the town would convey to Louis Tessino our one-half undivided interest in the property located off Douglas Street. Incorporated into the deed are restrictions on the use of the property in the future. It has to be used as a commercial retail development as specified in both the RFP and the purchase and sale agreement. And we've put language in there indicating not only that we're imposing these deed restrictions as part of the deal, but Tessino as the grantee covenants to abide by them in the future. And they'd be binding on his successors and assigns, and would be enforceable under General Laws, Chapter 184, Sections 26 through 30, which are provisions of law relating to deed restrictions or restrictions on uses of property. In essence, that's that document. Mr. Tessino, in addition to paying the balance of the purchase price as stipulated in the purchase and sale agreement, would pay the town a pro forma tax covering the period of time from the date of the deed up through June 30th, so that the town is made whole tax-wise for the entire time that the property is in private ownership. He will sign an arson tax delinquency statement, which is required under Chapter 60, Section 77B for tax foreclosed property, and he would sign a disclosure statement identifying all the parties who are going to require an interest in the property, which is also required by general law. Now we'll close the deal.
That same requirement wasn't met when they first signed the deal.
Yeah, I think Cherrier signed the...
Yeah, I know that, but he didn't disclose that Tessino had an interest in the property.
I don't think he did at that point in time.
Yes, he had a half interest, the same way we did.
Okay.
He did provide a disclosure.
Cherrier did.
Cherrier did, yeah.
Yeah, but Shelley, he didn't, he has to put down the name of everybody who has a beneficial interest in the property. Tessino had the same interest that we had, but that wasn't disclosed.
Oh, I see what you mean.
So we're using the original PNS, and therefore we extended it again, in theory?
In essence, there's been a dispute over interpretation of the purchase and sale agreement terms relative to the buyer contingency of pre-permitting.
Right.
As we discussed, I believe it's at one point in time in a meeting, there's a difference of opinion as to
who benefits by the pre-permitting provision, and thus who would have the right to waive compliance with it under the purchase and sale agreement. And by moving forward at this point in time with the sale subject to the deed restrictions, we're in effect getting the same benefit of the bargain negotiated in the purchase and sale agreement. The use of the property will be secured. The only thing that's not being required is that all the permits be obtained for the commercial retail development up front.
Right. I guess I didn't ask the question. You refer to the June 4th, 2007 PNS, but
Right.
that PNS, I mean, are we kind of taking the position that it then got extended an additional 30 days because the closing wasn't able to be met?
Well, what's happened is, as you know, it was extended up to September 29th,
Right.
2008. And prior to that point in time, both parties made it known that Tessino said, we're ready, willing, able to perform, let's do it. We notified him, well, we don't believe you've met the conditions of the purchase and sale agreement. In the subsequent discussions and negotiations that have taken place amongst ourselves, number one, and then myself and Mr. Tessino's attorney, we've agreed to try to work through the dispute on the construction of the terms that we've had by this approach, trying to draft a deed with deed restrictions that would be acceptable to both sides. So in effect, we're operating under the same purchase and sale agreement. The parties, rather than go to court and litigate the dispute, have agreed to try to work out a compromise resolution to the dispute, and we're doing that accordingly. I thus don't think there's any need to modify or further extend the purchase and sale agreement. It's 2 weeks. Is it 2 weeks? And time flies when you're having fun. 3-4 weeks now after the closing date, but given the public nature of the hearings, meetings that you've had to convene on this, that's why it's taken so long.
Okay.
And I haven't heard back again. I've provided, after I sent a copy of this proposed deed to the board, a few days later, I sent a copy of it to Mr. Tessino's counsel, and I haven't heard anything back from them yet either. I did speak to him just briefly a couple of minutes ago, and he indicated there were a couple minor things, but they were waiting to see what the board's position would be before getting back to me.
So do we take a motion?
Yeah, go ahead. Well, discussion, obviously, if necessary.
I'm not quite sure how to frame the motion. That's why I
Yeah,
said-
a motion to accept the consent, or,
I would recommend a motion along the lines of moving that the board vote to authorize the execution of the deed as proposed by town council.
Now,
I move that.
before you do that, now, you indicated that Attorney Lemire thought there might have been 1 or 2 minor.
Right, and if there are changes, I'll get back to you. I want this board to move based on the document we have before us now. I think we've done our
Okay.
negotiating.
Right.
but-
I mean, so his indication is minor changes to this particular deed, or just minor changes to something else?
I construed his comments as to relate to the deed, but it was literally 10 seconds.
Well, we can make a motion on
What's
this.
minor to him might be major to me.
Right,
Exactly.
exactly.
So,
We're gonna have to- But yeah,
Well, okay.
I move that the Board of Selectmen authorize the town manager to execute this deed that we have before us.
No, actually, the Board of Selectmen will be
We actually
executing
do
the
it.
deed.
Okay. Then I move that the Board of Selectmen execute the deed that's before us now.
I'll second. Well, actually, can I add to that,
Friendly
any,
amendment.
any changes need to come back before us for reconsideration? So that way, we have a chance to see it.
Okay.
I'll second.
additional discussion?
Yes.
Okay.
It mentions a 500,000 square foot more or less.
Mhm.
How much less?
That's just a standard real estate.
I know
plan.
it's standard, but,
Is that
so if
what
it's
the
standard,
original?
what's the answer? How much less?
4,999 would probably work. Now, it's typical, de minimis, one way or the other, is what would typically be applied as a standard, as a criteria. It certainly contemplates a development in the range of 500,000 square feet. But obviously, very few final plans may come out exactly to that number, so the plus or minus just allows for minor de minimis deviations from that size.
Now, let me read the next to the last paragraph. The within conveyance is made pursuant to the authority, blah, blah, vested by the town meeting. a certified copy, hereto as attachment A, and in accordance with the terms of the request for proposals issued by the town dated such, and the purchase and sale agreement dated June 4. So it is not correct to say that all the things that were in the request, in the response to the request for proposals are incorporated here. They're not. All of that is out the window. And the only thing you have left is 500,000 more or less commercial retail development.
Is that language taken specifically out of the RFP?
Yes.
Okay,
Well, what do you think is missing?
yeah.
Well, I don't like deed restrictions. Contrary to, I don't have the same view that town council has, that, oh, they're easy to enforce. They're not easy to enforce.
But they're hard to remove once they're there.
Well, they can stay as long as they want if you can't enforce them. What difference does it make? It's not, this has, no part of this, from the very beginning, has been in the interests of the people of Uxbridge. But I've said that 100 times.
Yeah, we've been down that.
to deaf
I know.
ears.
We don't all agree with that.
Any further discussion?
Excuse me.
Call for vote, all in favor?
Aye.
Aye. Opposed?
No.
Okay, I will relay the board's vote to Attorney Lemire, and we'll try to get it moving.
Hopefully he'll accept it as it is.
Otherwise, I'll tell him we're coming back.
The hot dog stand.
You want to go to see the board issued proclamation?
Oh, yeah.
What's the day?
Excuse me, National American Indian Heritage Month.
A month?
Month.
Oh, okay, which month? November?
Should have November?
Yes.
Or let me see the proclamation.
I move that the Board of Selectmen declare the month of November to be National
American
Indian Heritage Month.
Second?
Any further discussion?
No, it's just, I'm an American Indian, so I guess next month,
You get the month off?
like,
Well-
is that what I get?
Oh, would you like to decline the motion so that Cari can make it?
That might be a conflict of interest.
Oh, that's true.
But I'll
Does
be
that mean
happy
I have
if-
to
If you
abstain?
would like to, no, you can, if you would like to make the motion for the record, please be my guest.
No, that's fine.
You sure?
I can second the motion.
Okay, withdraw your second then.
I withdraw my second. Go ahead.
Thank you. Second that emotion. That emotion, second that motion.
Right, and.
Can I be an honorary Indian?
Yeah,
If you want to be.
Good. I'll open a casino on my property.
And we'll let the record show that Cari noted that she is of Native American descent.
Yes, I am.
Yeah.
Peter wants to be.
This isn't Native American month, it's Indian.
Same thing.
Right, yeah.
I'm a Native
That's
American.
my opinion.
We'll call for the vote. All in favor?
Aye.
Aye. There you go. Good.
164.
What is Seven Hills?
Seven Hills is a,
It's a social services organization that provides some.
Are they permanent in Uxbridge?
they are.
Yeah, they
they're
have the facilities
down
at the hot dog stand.
Pie shop next to the carpet place.
Oh, okay,
Right.
okay.
But they're a social services organization that have some businesses where they integrate people who are,
Okay.
building life skills, that kind of thing. And they've been operating that business for a while now.
Now, are they asking for a common victual license? Or they just want to set up on the street?
They want to take up a
They've already got a
parking
common vic
space
license,
in front
right.
of their building.
Okay. Do they need approval for that?
Prior boards have requested that those type of things come before, so
If they just did it, it would take more than a day for notice to percolate down to us that hot dogs are being sold, illegal hot dogs are being sold.
We are the Manny, and Manny has the.
Yeah, okay.
Unless they ask for forgiveness rather than permission.
and the street commissioners as well.
That's right, we are street commissioners, aren't we? Yeah.
I mean, I guess just for a clarification, so you said we don't necessarily have to hear these, it was just, this has been a policy?
Yeah, until the
An
board has
informal?
that meeting, now that you've had a couple months on the board as a full board, we need basically to matrix out, what do you want to come before you and what you
Right.
don't.
Okay.
Anyway, I'll move that we grant the request to place a hot dog cart in a parking space directly in front of Milestone's Ultimate Hot Dogs at 11 South Main Street.
On such and such date?
Second.
On the 12th of November,
From 10:30 to 2:30?
from 10:30 to 2:30.
And they have brown mustard available? Is that part of the motion as well?
Okay.
Okay. All right. Do I have a second?
Second.
All in favor?
Aye.
Aye.
Okay, so in the red folder, we have the election warrant
Okay.
for you to sign.
And if we don't sign it, the election won't be held?
Could it be that easy?
Do we need a motion or just actually sign it? We don't need a motion.
You don't need the
Or we
motion.
open ourselves to the whole Florida Chad thing.
But Kim, no motion needed, they just sign it at the meeting?
Okay. All right. The motion,
I move that we sign the warrant.
We approve.
Approve the warrant for the
November.
November election.
second?
Second?
All in favor?
Aye.
I abstain just because I'm on that warrant.
It's a ministerial task.
I know.
You don't have to abstain.
You want me to be the one that didn't sign the warrant?
What's that?
You want to be the one that didn't sign it?
Yeah, I guess I guess I should then. I will reconsider that and vote in the affirmative.
That's 5 ayes then, Kim.
It's 5 ayes, yeah.
You seconded?
Yes, I
Cari
did.
seconded it, yes. Okay. All right, and we'll sign it before we leave.
Yep.
Okay?
Pass it down.
And was there one more thing? The business name change?
I know, this is tough.
I didn't even find the hot dog one and all that. Well, this was all the things I did, but for some reason I can't find the hot dogs.
Okay, in August, George Matoso appeared before us for the Class 2 license. He's changed the name of the business from Dave's Auto Sales to Genesis Auto Sales LLC, and just we need to reissue the license to reflect the name change. A motion to do so?
So moved.
All right, second?
Second.
Okay, all in favor?
Aye.
Aye. Okay, sign that as well. Did you sign all 7 copies? Okay.
7?
Yeah.
Okay.
And then, the meeting minutes. Okay, we've got a number of sets of meeting minutes to approve. First being September 3rd, 08. Special session to the town manager position.
These minutes are very confusing, because once you start going through these, right, I have one that says September 8th, 2008, but on the back of it says September 16th, because they got mixed up in the process.
Oh, okay.
But, and the pages aren't numbered.
Right.
The thing is,
You should put them in a
It's-
footer.
yeah, but it's very important that the minutes be done the day after our meeting, and then emailed to us, so if we can see anything that needs to be changed while it's fresh in our memory, we can do it. But how do you go back 2 months and check minutes? I don't know how to do that.
Didn't we make a motion, though, that we were not going to get as specific in the minutes to help alleviate that issue?
I've been trying to do that for years, but I haven't been successful. We did have a discussion, but I didn't prevail.
I don't think there was a vote to that.
Does everyone have the September 3rd?
Yes.
Minutes in front of them?
I just found it.
Okay.
September 3rd.
I move that we accept the minutes of the special session meeting on September 3rd as written.
Second?
All in favor?
Aye.
Aye. All right, next set are the special session meeting minutes from September 11th, 2008.
I move that we accept the special session meeting minutes of September 11, 2008 as written.
Second.
All in favor?
Aye.
And we have September 16th.
I move that we accept the minutes of the special session meeting of September 16, 2008.
Second.
All in favor?
Aye.
Aye. Okay, and then we have regular session meetings on September 8th.
I wasn't here for this one, so.
I move to accept the minutes from September 8th as written.
Second.
All in favor?
Aye.
Aye.
Abstain?
Okay, that's 401. Mr. Potaski abstaining. Okay, November 22nd. Regular session.
Make a motion to accept, oh, this is draft, so why are these draft?
They're all drafts.
They're
Well,
draft
this one is
until
the
you
only
sign
one that actually had draft written all over it, though. So there was nothing different about it, that's just my
They're
question.
draft until you sign them, so
Okay.
that's Kim's way of making sure that they're signed.
You're cooperating.
That's fine. I make a motion to accept the minutes for September 22nd as
Second.
written.
All in favor?
Aye.
Aye.
Second. Cari.
Yeah, I'm not hearing everything over here.
Yep.
Oh, sorry. I'm also stuffy.
And just one typo on page 2 of the October 6th meeting. Third paragraph down, second line, up the board, is spelled barred. So it's just a little typo there. Page 2 of the October 6th, third paragraph down. Second line.
Okay.
But it's all no content errors.
Motion to accept the October 6 minutes as written with the exception of the typo.
Second.
All in favor?
Aye.
Is that it for the minutes?
That's it for the minutes.
There was a time that the Board of Selectmen in Uxbridge went more than 2 years without approving minutes.
Really?
And it wasn't that long ago.
Well, then we're doing good.
Yes, but it's easy to slip into that, believe me.
Yeah.
Because it gets overwhelming. So we need to get the minutes done the next day, number one priority.
It's close thereafter.
The next day,
I'll believe you.
unless the building burns down, because then it's fresh in your mind. Hmm?
mold in the basement.
Or mold in the basement,
It's a great job for the.
because of a
for
compromised
Clerk
pipe.
Robertson.
Okay, we have something to address in executive session. Everything else, we'll pick up.
What's the date you guys?
Oh, we
want?
haven't picked a,
Pick a date. Peter, do you have school committee next week?
What time we got
It-
tomorrow, Mike?
What's,
9:30, here, right here, right?
it will be a Tuesday. I think we put it
You
off.
guys meeting on election day?
I don't think so.
I don't think you are.
a hard time.
Okay, and then, so I would suggest Wednesday or Thursday?
What week is it?
This is the week of
So
the
the
3rd.
5th.
What's Wednesday?
Wednesday is ZBA, Wednesday the 5th.
Is that the day of the, is that still November, or is it, that's November?
It's November.
Yeah.
3rd?
No.
This-
5th.
Wednesday. the
5th is okay.
What time on the 5th? 7 p.m.? That'll work. No?
I have no clue, so.
Bruce, you okay on
Oh, sure.
the 5th at 7? Peter?
Yep.
Okay, so we have then, old business, we'll continue with the fall town meeting warrant review.
Yep.
consider a joint meeting with the PEC and BOS regarding the GIC.
Yep.
Department of Planning and Economic Reorganization Assessment, access to town council policy.
Yes.
That's it?
Yep.
Speaking of which, is my friend going to be here every meeting now? Is this what we're doing? No?
Just to
No.
irritate you, Peter.
Yeah.
It succeeds.
That's why we have to sit next to you, too.
Hope it's not personal, David.
Maybe there's a pandemic. FinCom, I have them on the 3rd.
Our prior policy was once a month. I would come out for meetings, and we tried to schedule it around the selectmen's meeting so that I could be there. But if you want to change that, then
Yeah, I would, once a
I won't
year.
take it personal.
I don't see a name tag, I see dollar signs, yeah.
No, you're free.
Not costing you any more.
So we agree on the 5th, Wednesday the 5th.
They're trying to find.
All right, I need a motion to go into executive session, discuss strategy relative to collective bargaining,
With no business after?
with no business to be conducted afterwards.
So moved.
Okay,
Second.
by roll call vote.
Potaski, aye?
Robertson, aye.
Desilets, aye.
Baghdasarian, aye.
Kuros, aye.